The hour is 9 a.m. and I call this meeting to order. Mr. Casey Griffin on our staff will call the roll to establish a quorum. Mr. Griffin.
Mr. Cobbins.
Here.
Mr. Holt.
Here.
Mr. Gentile.
Victoria Harpel, designee for Dr. Gentile.
Mr. Jensen.
Here.
Ms. Johnson.
Here.
Ms. Maxwell.
Here.
Ms. McIntyre.
Here.
Mr. Mullenhour. Ms. Sapp. Mr. Wells.
Here.
Mr. Chairman.
Here.
Mr. Chairman, you have 9 members present.
I declare that a quorum is present and we are duly convened. You might have heard a new name that Mr. Griffin called, Ms. Sapp, Brittany Sapp from Britton Sapp from Bradley County is our new student board member, and we're excited to have her. Look forward to her. She was just appointed, I think, about 3 days ago, and so without objection, she is excused from this meeting. This time I'd like to recognize any members for their remarks, and then we'll have Dr. Morrison make any comments. Any comments? I would just say I thought we had an excellent workshop yesterday. Covered. Oh, Mr. Holt.
I'm sorry, I wasn't fast enough on the draw. So for just a member report, I wanted to mention that the Strategic Planning Committee of the State Board of Ed had a good meeting over this past month that we've convened and have talked about what our strategic plans look like, how we want to evaluate that going forward, discussed adding some potential numeracy goals to those standards, and then also have approved a stakeholder survey that's going to be going out soon. So I just wanted to let everybody know about the work being done there.
Excellent. Thank you. Other comments or reports? As I said, I think yesterday we had an excellent workshop. A couple of the items that we talked about actually were associated with strategic planning. The strategic plan from the higher ed certainly is one, and we talked about the importance of integrating each one of those together so that we have an overall, looking at P through 20, the strategic, what we want to do for our students to meet our mission to best prepare them for post-secondary success. I think we had a healthy discussion on the world language requirements, and I think every one of us learned something from there. That was very valuable. With that, Dr. Morrison.
Thank you, Chairman Eby. It's good to be back together this morning. We did, as you said, had a really full day yesterday, as we always do with our workshops the day before these meetings. So if those of you that are with us in person or online are interested in going back to watch some of the conversations from yesterday, I would certainly encourage it. We heard from Dr. Laird and Dr. Keeney at the Department of Education, where we took a look back at this last year's TCAP results, dug into some of the data there, and really we're excited about what we're seeing across the state. Certainly there's more to do and more work ahead, but the educators across our state are really working hard with students, and the results are in the data. So that was great to spend some time in that conversation with our partners at the Department of Education. We heard from SCORE about the TN30 plan that they've recently released and some of the work they're doing locally to make that accessible for districts and schools, thinking about what would the data look like if we had one more student in every classroom becoming proficient. And again, that was a great conversation, particularly, as Mr. Holt said, as we think about our own strategic plan. And similarly, we heard from folks at the Higher Ed Commission, Victoria Harpel's colleagues, about the work that they are doing. They are still in the process of developing their strategic plan at THEC, so it was good to have conversation about how we can think about alignment across our planning and their planning. We also heard from Allie Reed and our team about some of the new charter responsibilities and changes in recent legislation that put a few new things on the state board's plate and also open up some different pathways for authorization. So that was also a good conversation. We ended the day with a really robust conversation about world languages and graduation requirements. I know we'll be coming back to that today, but appreciate everyone really engaging and coming with informed perspectives about that conversation that Chairman Eby has put before us. Before I turn it back over to you, I failed yesterday to introduce a few new team members. So just briefly, if I could turn to Rachel Supay first to introduce some of our new and outgoing legal team members.
Absolutely. We have some new faces on the legal team. And our intern, law student intern from Vanderbilt, today is her last day. So Tori Mitchell, I'm going to call on you just to thank you for your time and all of your hard work. And we're excited to see all the exciting things ahead for you. And we have a new intern also starting today. He is in class at the moment, but his name is Ethan Moore, and he is a law student at UTK. So we're excited to have him on the team as well. And then we have a new attorney, Jamie Formont. Jamie's joining us. This is her first week, and she has a lot of great experience in state government, so we're happy to have her on the team to be helping with mostly licensure cases. So welcome to all three of you. Thanks, Sarah.
Great, thank you, Rachel. And then lastly, but not least, Josh Walton, who joined us in time for our special called meeting a few weeks ago. He's leading all of our communications work, public information officer. He's doing a killer job in his first in-person meeting this week, so we're really thrilled to have you on the team, Josh. Welcome.
Thank you. And with the announcement that Britton Sapp is our new board member, I think it's also, we ought to recognize Bonzi Alberson, who served so greatly for her year plus. And for Britton, student members are very important members of our board. You bring a perspective that the rest of us don't have, and I think Bonzi did that throughout the year. So thank you, Bonzi, if you're watching this. I want to remind all presenters to give their names and positions before addressing the board. Also ask that presenters avoid unnecessary jargon. One of the main points of public discussion is to ensure that any Tennessean watching the proceedings can follow along and understand our discussion. With that, we'll go to our first item, which are our consent items. We have 3 items on the agenda: the adoption of agenda, minutes from the May 30th and July 30th meetings, and licensure discipline settlement approvals. Is there a motion to accept the consent agenda items as presented? We have a motion by Mr. Wells. Is there a second?
Second.
Mr. Mullenhour seconds. Is there any discussion for the consent items? No discussion. All in favor for accepting the consent items as presented signify by saying aye. Aye. Opposed? Motion carries. Next item are our report items. First item is our State Board of Education member reports. We already had one report from Mr. Ryan Holt. Appreciate that. Are there any other board members who would like to give reports on activities that you've been doing since our last board meeting? Vice Chair Cobbins.
Yes, sir. I mentioned yesterday, but I'll mention again that in June, had the opportunity to join Erica Light and Michael Derline in convening the Educator Preparation Advisory Council. That agenda consisted of looking at new state laws and how they potentially impact the report card that we produce. And we talked about the metrics and any potential adjustments that might need to be made to those. So that was a good meeting, and thank you for allowing me to participate.
Thank you, Vice Chair Cobbins. Any other comments or questions? Ms. Maxwell.
Thank
I wanted to thank the SBE staff for the second learning session that they conducted this summer. As always, it was exemplary and very informative, and I appreciate that. And also, a couple of days ago, I was with the Upper Cumberland Superintendent Study Council. Thank you.
Thank you. Other comments or questions? Ms. McInturf.
This summer, I was once again able to attend the Tennessee Civics Academy at UT. Mr. Eby, you were there with me. I was able to be on a panel, which was awesome. It was 2 full days of really good learning and speakers. And I'm also on the task force committee, and we'll be meeting next week. And I'll also be at a TSBA meeting on the 25th. So I've got a lot of things on the calendar I'm excited about.
And I don't know if we announced or not, but Ms. McInturf has been promoted to principal now, and so
Very excited.
Congratulations for that. Well deserved for sure. Other comments? I'll mention a couple of things. This summer, a group of us went to the Education Commission of the State's meeting out in Salt Lake City, which was an excellent, that's always an excellent conference to go and hear what's going on across the nation and some of the challenges that we have and some of the challenges that they have across the state, and to hear those. That was a very informative meeting. We have some upcoming meetings coming. There's the Tennessee Organization of School Superintendents has their annual fall meeting. I think we have several members that'll be going to that, as well as Ms. McInturf says, TSBA meetings across the state at the various core regions. And I also attended the East Core Superintendent Study Council meeting earlier this week. That's always a great opportunity for us to hear from superintendents and the challenges that they have and how we can meet their needs. that, we'll go on to our next item, which is the 2023-2024 Virtual Education Program Annual Report. Ms. Lou Harless.
Good morning, Mr. Chair and Board. My name is Lexi Harless, and I am the Policy and Research Analyst with the State Department of Education. I'm here to present the department's report of virtual education programs and represent the hardworking staff that annually produces this report. In compliance with state law, the report provides information relative to the operation and viability of public virtual schools and virtual education programs. Information within this report is based on school data from the 2023-24 school year and includes data related to student enrollment, academic performance, and funding for public virtual schools and their establishing LEAs. I'm happy to answer any high-level questions you may have, and we'll work with our staff to provide responses to any questions that require more content expertise.
Is that it?
Yes.
Are there questions? I have a couple of questions. When we look at the virtual report, looking at test scores and how students do, can you give us some alignment on how we continue to try and improve results for virtual schools and virtual test results, and how are they compared to in-class test, in-class results?
Yes, thank you for the question. So related to the accountability, there are a couple of measures in place. First, LEAs choose to establish virtual schools. They fill out a school approval form just as if they were opening a new in-person brick and mortar school. The department reviews each request and works with the establishing LEA to ensure that the virtual school's operational model aligns with all statutes, rules, and regulations related to public virtual schools. It is also within the LEA's discretion to define the type of enrollment that their virtual school will allow, including enrollment only for in-district students, enrollment for both in-district students and students who reside within nearby geographical districts, or enrollment that is open to students statewide. Public virtual schools are also held to the same rigorous standards as traditional brick and mortar public schools and are funded in the same manner as other public schools. They earn letter grades under the same accountability framework as other public schools across the state. However, state law provides an added layer of accountability and oversight so that if a virtual school earns a TVOS growth level of significantly below expectations or a level 1 TVOS score for 3 consecutive years, the commissioner may either recommend to the LEA that they close the school or institute enrollment caps. So there's the accountability at the local board level to decide what they would like to do about the virtual school. And if they have consistently low performance, there's a mechanism for the state to step in as well. Additionally, like traditional public schools, public virtual schools and their establishing LEAs are required to submit annual school plans to the state's school planning system. These plans help LEAs and their virtual schools move the needle towards academic success for their students. Additionally, the department has established a virtual school monitoring framework for LEAs to evaluate the academic, operational, and physical capacity of their public virtual schools. Annually, monitoring data is used to refine and enhance the monitoring framework for the next monitoring cycle. These processes include ensuring the teachers are properly licensed and endorsed to teach in the state, and that virtual schools are using state-approved textbooks and instructional materials, or that they have obtained waivers approved by the state board. The department plans to continue tracking the performance of these schools and will continue to collaborate with LEAs as necessary to promote student achievement.
Thank you. Can you compare how those achievements are for the virtual schools as compared to traditional in-person schools?
Yes. So historically, they're with the public virtual schools, they do underperform compared to those in-person schools. However, looking at those letter grades, they tend to perform they do, just trying to find a way, performing somewhat similarly, but still underperforming.
Okay. And there are both synchronous and asynchronous virtual schools, is that correct?
I believe so.
Okay.
I would have to go and check with our program staff.
I was curious how the comparison of those were too.
I do not have that information on hand, but I'm happy to work with our program staff to get that information for you.
That'd be helpful, thank you.
Yeah.
Mr. Chairman?
Yes, Mr. Holt.
I'm looking on page 9 of the report, and it looks like it shows that 62% of the virtual schools in Tennessee scored a level 1 on TVOS, so the lowest growth level for the past year. which is nearly 3 times as high in the lowest growth level as non-virtual schools. And so I'm wondering, one, like approximately how many students are in these level 1 virtual schools? And then also, do we know how many of those have been scoring level 1 for 3 consecutive years, which would then invoke that possibility of some sort of intervention?
So I do know that in the report there, in the appendix, there's information on the enrollment for each virtual school. And we do have the data for the accountability for those letter grades. I believe in one of the appendix it has the 23-24 letter grades and also the 22-23, but I'm happy to find that information for you as well.
And then specifically on the number of virtual schools that would fall within the intervention capabilities for the state of the 3 consecutive years of level 1 on TVOS. I mean, just noting that nearly 2/3 of the virtual schools, at least with the most recent data, scored a level 1, makes me think that there's maybe a decent number of schools that have scored level 1 for 3 consecutive years. And if you know how many there are and what the plan is for them.
So I do not want to speak on behalf of anyone who does have the responsibility to do that. I know that we do have that data for how many of those schools have received a 1 on TVOS. Unfortunately, I do not have that in front of me, but I'm happy to get that to you.
That'd be great, thank you. And then also, if there are any thoughts on whether the intervention capabilities, if that's something that the state might exercise, or what other plans might exist, if there are a number of schools that are persistently scoring level 1 in TVOS. So, thank you.
We'll get that for you. Okay.
Other questions or comments? Thank you, Ms. Arliss.
Thank you.
Next item is TISA allocations, Ms. Mary Ann Dursky.
Good morning, Mr. Chairman, members of the board. I'm Mary Ann Dursky, the Chief Financial Officer for the Department of Education. In 2022, the General Assembly passed the Tennessee Investment in Student Achievement Act, or TISA, which transitioned Tennessee to a student-based funding formula for education. This was the first major revision to the state's education formula in 30 years. The formula will be used to generate funding for our schools in the 2025-26 school year and is supported by a $164 million investment of additional state dollars for the 25-26 fiscal year, including $125 million for improving teacher compensation. The allocations include a base amount of $7,295 for each average daily membership, or ADM, across the state. They reflect a base, weighted, and direct allocation for each district. They reflect a 70% state share of the base and weighted allocations, with the remaining 30% being shared collectively by all of the LEAs. And the allocations reflect a 100% state share of the direct and outcomes allocations. To determine the local contribution for each LEA, the formula equally weights the ability of local jurisdictions to raise local revenues by measuring the ability to generate local revenue from property tax and local option sales tax based on a model developed by the Boyd Center for Business and Economic Research, or CBER, at UT Knoxville. And secondly, the ability of local jurisdictions to raise local revenues as determined by the multiple regression analysis model developed by the Tennessee Advisory Commission on Intergovernmental Relations, or TASR. Tennessee Code 49-1-212 requires that the department prepare a fiscal analysis of any policy, rule, or regulation proposed to the State Board of Education. The attachment before you outlines the TISA allocations each LEA will receive in the 2025-26 school year. This item does not require any LEA to increase its local contribution in order to meet the TISA required local contribution amount. This item is for informational purposes only, and no action is required on the part of the State Board of Education. I'm happy to take any questions.
Thank you, Ms. Dursky. Are there any questions for Ms. Dursky? Thank you.
Thank you.
Next item, we'll move on to automatic teacher licensure actions. Mr. Todd Madison, Alex Anderson, and Ryan Shanahan.
Good morning. Todd Madison, Senior Associate Counsel for the Board, joined by Alex Anderson, Ryan Shanahan, Jamie Formont, Associate Counsels for the Board. First item we have for you are the automatic actions. State law, board rule require the automatic revocation or the automatic permanent revocation of an educator's license for certain criminal offenses and classifications set forth in law. Additionally, the board is required to prevent such individuals from reactivating an expired license. The listed individuals have either been convicted of one of the specified criminal offenses or their conduct meets one of the classifications provided in board rule. As such, we recommend the approval of these items.
We have a recommendation for approval. Is there a motion for action?
So moved.
Vice Chair Cobbins moves. Is there a second? Mr. Holt seconds. Are there any questions for the legal team? No questions, then I'll ask Mr. Griffin to call the roll, please.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
The motion passes. Thank you. Members, we usually deal with, the next item up is teacher licensure discipline actions with the same legal team up here. Normally, we deal with these en masse as on a consent agenda. On this agenda, it isn't listed that way, so I'm going to first ask members if they have any of these cases that they would like the board to take up separately. And then following that, with unanimous consent, we'll consider the remaining items in Section 4 as a consent agenda. Do any members have a request to take up any of the licensure discipline items separately? Mr.
Chairman.
Mullenhour.
I'd like to pull out Joseph Dalton, please.
Okay.
Thank you.
Josh Dalton will be pulled out. Any others?
Joseph Dalton.
Joseph Dalton.
Yeah, item B. Thank you.
Any other? Okay, we'll pull those out. So except for Joseph Dalton, is there a motion then to accept the other recommendations as a consent agenda item? Mr. James.
Yeah, we would just need to create the consent agenda by first getting unanimous consent and then the motion to approve.
Okay. Is there unanimous consent then to group the rest of these as a consent agenda item? Are there any objections? Thank you. There is a move. Is there a second? Ms. Johnson seconds. Since this is a consent agenda item, that would not require a roll call vote to agree to consent. So all in favor for accepting this as a consent agenda item signify by saying aye. Aye. Opposed? That motion carries. Now we'll vote on those items as the consent agenda. They will require a roll call vote. First, I guess I need to have a motion to accept the recommendations of the legal team for that. Is there a motion to accept the legal recommendations for each one of those on the consent agenda?
So moved.
Mr. Mullenhour moves. Is there a second? Ms. Maxwell seconds. Is there any further discussion? If not, then Mr. Griffin, please call the roll to accept the recommendations.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. So now we'll pull out Mr. Joseph Dalton. And Mr. Mullenhour, do you want to ask questions first, or do you want to have our legal team to present the case?
Thank you, Mr. Chairman. I would ask that the legal team first present kind of your framing of this particular issue, and then may have a few questions or comments after that. Thank you.
Yes, sir. So Mr. Dalton was reported to the board for having inappropriate physical contact with students. The investigation led to criminal charges being filed against Mr. Dalton. Ultimately, he pled to 5 counts of assault against students. It's framed as offensive touching of students. He received 6 months of criminal probation due to be concluded in November of this year. Our recommendation is in line with the criminal court's sentencing of 6 months of probation, which historically is what's been approved by this board in similar cases. So with that, I'll let Mr. Mullenhour ask any questions he has.
Thank you, Mr. Chairman.
Mr. Mullenhour.
Todd, just a couple things just to make sure that I'm understanding the matter correctly. The body of evidence that you received or that this board received consisted of a compilation of approximately 7 minutes of security video footage. Is that the totality of the evidence that we were presented with?
That's correct. In this instance, which is pretty common whenever law enforcement gets involved, they instruct the school district to be hands-off and leave the investigation up to law enforcement. So what we have is what has been provided to us by the district attorney's office.
Okay. And it's my understanding that in the course of the criminal proceedings, Mr. Dalton indicated to the judge that he intended to not return to the teaching profession. Is that correct?
That's correct.
Okay. And would it then be correct to sort of restate what you just said as follows? We were made aware of an issue sort of concurrently with law enforcement being made aware of this issue. Law enforcement investigated it. The state board essentially paused any investigations pending the criminal investigation, and then sort of picked up the matter once again once the criminal matter had concluded with, in this particular case, a guilty plea. Is that all a correct framing of what occurred?
Yeah, that's accurate.
Okay. So now a couple comments. I'm still a little perplexed with this particular matter. On the one hand, we have someone who has pled guilty to 5 counts of misdemeanor assault. On the other hand, for those who have seen the videos, I have seen the videos. I have a hard time perceiving from just the limited evidence that this board received that Mr. Dalton is guilty of what he's pled guilty to. So that's the dissonance. That's the part that I'm having a hard time with. We have someone who has essentially admitted that they did something wrong, but the evidence that we have is very limited. And I would strongly state that it doesn't support not only the fact that he would have pled guilty, but the fact that he would have been accused of it in the first place. So I have to assume that there's other evidence out there that the prosecution had privy to or that the judge had privy to that we may not be privy to. And the reason I'm saying this is because this is a matter that has been in the press a few times, and there's some very strong opinions, there's some strong emotions on kind of both sides of this issue. And I think it's partly because there seems to be a disconnect in kind of the outcome so far, and again, the limited evidence that we have. So we're in a situation where our legal team, has looked at the evidence that they have, and they've said there's not much here. But at the same time, we're faced with the question of, we have someone, even if we don't have video footage of it, we have someone who's pled guilty to 5 counts of misdemeanor assault. Do we want this person in the classroom now, and do we want them in a classroom ever? So, I'm having a little bit of a hard time reconciling this particular matter. And what I would like to propose is that we, first of all, recognize that, and I really want to be very clear in this because, for anybody who's watching the matter and who may intend to write about it, we need to start with the fact that our team, the state board, and our staff has very limited evidence on this matter. And they have to make the decision in their recommendations based on the limited evidence that they have. So we start there. And at the same time, I can't in good conscience ignore the fact that someone has pled guilty to 5 counts of misdemeanor assault and think that it's okay that they would ever teach in a classroom in Tennessee again. And then you pile on top of that the fact that the gentleman has indicated that he doesn't intend to teach in the state of Tennessee anyhow. I do recognize that we need to be very careful about setting precedents, and we need to be very careful about, for example, revoking someone's license based on this particular evidence, the video evidence that we have, because if we revoked every license of every teacher who had similar sort of documented behavior, I think we would have outcomes that none of us are comfortable with. The difference in this case, in my mind, the key distinction in this case is even if we don't have video evidence of what this man was accused of doing, he admitted to it. And in my mind, that's enough to say we're going to revoke that license and not run the risk of 6 months from now or 12 months from now or 10 years from now having a child subject to similar offenses and have to answer for the fact that we were aware that he had admitted to doing it before and maybe now he's done it again. So, Mr. Chair, I would like to make a motion that we simply revoke this license. I realize that there are some legal implications to that. Todd, I don't know how much you want to get into that now, but I would like to, of course, hear other feedback from each of you as well.
So we have a motion then to revoke the license. Is there a second to that motion? I will second that motion. So we have discussion at this point in time. Ms. Johnson.
I just want to make it public knowledge to those that have not had privy to the video that we had privy to. The inappropriate scenario is that the gentleman hugged the students for a longer duration than seemed appropriate. 10-year-olds are going to be very loving. It was obvious that he was liked by his students. Do I think what he did was appropriate? No. Do I think after 20 years of teaching, he felt comfortable with his setting? Yes. He knew he was being videoed at all times because you know that's happening. I think he got a little bit friendly in regard to the hugging of the students. Now, to revoke his license, I feel that might be a little harsh in that this is a professional who's been in the classroom for over 20 years. We don't know his personal reasonings, but I think with professional development or with counseling, that it might be appropriate that down the road, since he did plead guilty, he may be worth saving. The other thing is, when you're in the light of criminal charges, you sometimes agree to the charge because it's less public than fighting it and saying, oh, I didn't do it, because then you delve deeper into a situation. So that may have been why he pled guilty in the first place.
Mr.
A couple
Jensen.
of questions. Do I understand he has indicated that he will not return to teaching, or that he indicated that to the judge? I'm leaving the classroom.
That's correct.
Of course, we're not charged with adjudicating this matter, but the question that seems apparent is if we did not revoke it, that if he decided to come back to teaching, that there are fairly something that we or somebody's telling him, this is what you've got to do in order to get your license activated again. It does trouble me a little bit that he indicated to the judge, I'm not going to be teaching anymore, and we're dealing with the question of of doing something with his license other than revoking it. And he's indicated, I'm not going back. So it's a little bit troublesome to me that, as you have indicated in the court, he said, I'm not going back, and now we're positioning where he potentially could go back. And I think we've got to be very clear across the state about these issues. We've dealt with this before in here, and I just think we need clarity around what is unacceptable in terms of children. And 20 years, I understand all that, but that still doesn't validate that that's an acceptable behavior. We've said it's not acceptable. And I'm troubled a bit by his saying, I'm not going back, and now we're doing something that basically preserves his right to come back. And if he did, it seems like we need some things that maybe it comes back to us or somebody that looks at it and said, yeah, you can go back, but you got to do these 2-3 things in order to get there.
Other comments?
If I may,
Go ahead.
Mr. Jensen and Ms. Johnson, there's an element of professional development tied to the recommendation. So once this suspension period expires, there's still that element that he needs to satisfy if he did ever want to pursue his teaching career again. As far as his license goes, until that's satisfied, his license is invalid. And that'll remain that way until he addresses those issues. It is also an option of this board to increase that level of professional development that is required of him to come back into the profession if he ever does wish to return. As you guys have indicated, he has said as much that he has not or does not wish to return to the profession, but that could be another level of professional development if you wanted to increase that to hold him accountable as far as making sure that those issues are addressed before returning to the classroom if he did choose to do so.
Let me ask a couple of questions. First, if he did return, applied for a job someplace, he has to acknowledge that he pleaded guilty. Is that in the consent agreement, I think?
Yes, he does.
Okay. Going back to what Mr. Jensen's comment is, as I look at all these cases that we have looked at, there's, 5 or 6 of them that have to do with issues where teachers respond like grabbing somebody or doing something. It's almost a instant response, which is difficult in the teaching job. But it seems like to me training, going back to what you're saying, that we've got to do a better job in our EPPs and in our districts for training people of what they can do and what they can't do. There's no excuse for going above and beyond, but I think we've got to do a better job of training our teachers and reminding them. I know in my field, I get annual training on what I can put on my computer and what I can't, et cetera. So, what I hear is that's not an annual training requirement that we have across the state on what you can do and what you can't do as a teacher. I may be wrong. I don't know. Ms. Reynolds, Commissioner Reynolds, do you know what the requirements are for training for teachers annually, if it addresses anything with regard to in-classroom behavior?
I don't know. Taylor, do you have, do you want to respond?
I'm happy to weigh in as well.
Okay.
If that would be helpful. Oh, I didn't see Taylor up there. To answer the question, I'm not aware of any legal requirement that specifically would require teachers to annually get trained in something like de-escalation or not putting hands on students. There are some specific related trainings, I'd say, like mandatory child abuse training, but I'm not aware of anything that would require all teachers to get trained on a situation like this, but I certainly defer to Mr. Jenkins as well.
I recognize this is only a small percentage overall. If you look at the number of teachers compared to the number of teachers that we have across the state, this is a small percentage. But any teacher that does something wrong that we have to take action on. We spend time taking action on. We lose that teacher out of the classroom for 6 months or 2 years or permanently or something like that. What can we do? So, Mr. Reed, go ahead.
Good morning. Taylor Jenkins, Deputy General Counsel at the Department of Education. I will add to Ms. Suppe's comment that teachers are required to undergo annual refresher training on the Tennessee Teacher Code of Ethics.
Does that include what you can do and what you can't do?
It does go through those judgment decisions, inappropriate contact with students,
Okay.
yes.
Thank you. Thank you. Then going back, continuing my comments, the 6 months gives me pause. I mean, that just seems short particularly for somebody that's, done this, pled guilty for five different times. And I don't know if there's an interim there of 2 years or something that we might consider, which would give that person, we would have a better idea if in fact that person was going to come back and teach again. But just allowing them, leaving it as what we have, 6 months, and taking their word that they're not going to come back and teach, doesn't mean that they won't be back in 6 months to teach. So that was something that gave me pause, was just looking at the 6 months. Just seemed nice. Chair Cobbins.
How long is the criminal probation in terms of
It's for
duration?
6 months, which for a B misdemeanor in criminal laws is the maximum.
For each one, or?
No, 6 months total.
Okay. Ms. Johnson.
Do we know what type of professional development that is being required of him if he were to ever go back?
I believe what we have required is professional development in boundaries, class management. But again, that it's something that y'all are able to tailor to whatever you think is most appropriate, and set a specific number of hours that you would like for him to complete. But as it is now, that's what's in the consent order that he's agreed to.
Mr. Chair.
Mr. Holt.
Am I correct that the reason why the recommendation was a 6-month suspension is because that's consistent with past instances where the suspension that we have recommended has been the same as the amount of probation in a criminal case?
Correct.
So if we were to increase it here, I guess we just need to be thoughtful about sort of the change to our past precedent, and in circumstances where maybe because of contact with students or things like that, that we're a situation we're saying we're going to impose a longer suspension of a license than the criminal probation because of reasons like contact with students or things like that, just so we're consistent going forward and comparing that to the past.
Mr. Chairman.
Mr. Mullenhour.
First of all, I'd like to thank Ms. Johnson for her comments. And, as I sit here and think about kind of, again, I'll use the term dissonance, like why is this a sticky one? In my mind, I think we each have to ask ourselves the question, what is the assumption that we are making with respect to the evidence? Are we assuming that, for example, the evidence of the action is what's before us, the 7 minutes of videos? Or are we assuming that there is something else out there? And I don't know what the right answer is. What I have to kind of weigh in that case is that, we have a district attorney here, Ryan Desmond. I don't know him personally, but I've heard that he's competent. I've heard that he does a good job. His office prosecuted this matter, investigated this matter, and so forth. I'm assuming that they have evidence beyond what we have seen. That's the assumption that I am making. If you assume that the only evidence is what we were presented with, I would side with Ms. Johnson. This would not strike me as being something that would warrant pulling somebody out of the classroom forever. But I'm on the side of the line of the district attorney did his job, his team did his job. In fact, they did their job to the extent that the defendant saw fit to plead guilty to it and not contest it. And it may be for reasons that you've articulated, I don't know. But we have someone here, and just to very briefly read the elements of the charge here.
Can you move your mic a little bit
Yeah,
closer?
sorry, Mr. Dalton is essentially saying that any reasonable person would regard the physical contact as being extremely offensive. So he's saying, I did that. That's where I would, again, just highlight the question, do we, even if we haven't seen the evidence ourselves, if someone says, I did those things, do we think that they should ever be in a classroom again with children? I think that's the question at hand that would support a motion to simply revoke his license, period. And the fact that he's indicated that he doesn't intend to teach, I think probably helps a little bit. I would also emphasize that while he may be required under the agreement, the consent agreement, to notify future employers that this happened, that doesn't mean he's going to. And we've seen plenty of instances where people don't. But if we take his license, it makes it really hard for him to find employment, even if he does lie on an application. Thank you.
Any further comments or
Mr.
questions?
Chairman, I do have
Yeah,
one
Mr. Jensen.
This or any of these go into a teacher's record, I assume. And while he says, I'm not going to teach here, could he go to Alabama or Georgia, and would they be able to, not just him, on any of these, that record follows them, or you're not allowed to give that information to another state? Follow my question?
Yes, sir. There's a national clearinghouse. I think all the states are a part of it. If not all, most of them are, where any of our actions that we take, we report to that clearinghouse. So if you were to go to Alabama, Kentucky, any of the surrounding states, wherever, it would be in that database. They would have access to it. And it's routine for them to reach out to us if they want more information on that particular instance.
Any further?
Thank you.
Mr. Mullenhour.
Todd, I sensed a pause in you a second ago, so I'm just going to ask, just to be real clear, is anything that I have articulated today, is my understanding incorrect or incomplete, materially incomplete in any way? Because this is, again, there's a lot of nuance here. I want to make sure that I'm not misrepresenting anything that I've said.
No, I think you've summarized it accurately. As you pointed out, there are some assumptions being made as to what we don't know and what is actually before us. So, to your point, he pled guilty to those actions that you see in the video. So that's what he's admitting to. And then it wasn't put forth in a trial for those elements to be proved, whether or not that conduct meets those elements. He went ahead and took ownership of that. So I'm not aware of anything else that's outstanding that we haven't been provided, while what we've been provided is limited. I think that is the extent of it, and I don't have any reason to believe that there's anything beyond that.
Thank you.
Mr. Wells.
Can you help me? I'm trying to recall the video in my head, but was it more than one student that he was accused of having inappropriate contact with, or was it just one? I feel like I saw one over and over and over, but I wasn't sure if there was others.
There was others, but I think you're right that there was a specific student that seemed to be involved in most of what was presented.
Ms. Maxwell.
Todd, just to be, for my own clarity, one, is there other evidence available other than the videos that I've seen regarding this situation?
Other than the criminal conviction, no.
And also regarding the 22 pages that were uploaded and the investigation papers that we saw, there were some phrases that have been alluded to. Were those Mr. Dalton's phrases talking about did intentionally and knowingly cause physical contact with another person, and that a reasonable person would regard that contact as extremely offensive? Were those his words on those documents, or were those the investigator's words on the documents, for clarity?
Can you specify which document?
It's the criminal court forms at the top, and then there's like a 4 or 5 line typed comment. It's probably about page 6, 7, 8, maybe. Sorry, I didn't write down the page number.
Is it the one that's titled Affidavit of a Complaint?
Yes.
Yeah. So that would be what the investigator has typed up in their affidavit. And I would say that's pretty much boilerplate for the affiant. Is he's listing out the elements of the crime so he can, justify the arrest and the charge.
Thank you.
Vice Chair Cobbins?
Well, my question was similar to Ms. Maxwell. I just wanted to ensure that we had either requested or explored any additional evidence that there might be with the prosecutor directly.
We have. I had a phone conversation with the DA who ended the case, and he was open to providing us whatever they had. So the video that's been referred to, that was the video that was played in court. So that was, according to him, the primary evidence that was relied upon.
Other questions or comments? We have a recommendation and a second. Yes, Mr.
Chairman,
Page.
I was just going to add one thing, if that's all right. Rachel Supay, General Counsel. I did want to just flag and remind, the board, a lot of times when we have these reviews, educators often will tell us that they have no intent to return to the classroom. I think that's a pretty common statement sometimes that we hear, whether it's the district level investigation or our review process, or in this case, a criminal process. Sometimes just having to go through that can really, of course, take the wind out of your sails, and perhaps you need a break from teaching. And I only mention this, I would say, to caution against making your decision based on a fear completely that a person may or may not return to the classroom. I think by that logic, we would be potentially talking about recommending revocations for any kind of discipline if we're concerned about the person kind of returning one day and engaging in that conduct again. So that would just be my only flag is, this is a common statement that we hear about not returning to the classroom, and I would not want that to be the main deciding factor given, like I said, that it is so common, and by that logic, we would be, I think, recommending revocation anytime we had a concern about a behavior.
Let me ask a question. If we rejected this motion that's on the table, then we still would have to make a motion either to accept your recommendation or to have some other, is that correct?
I believe that's correct. I'll yield to Mr. James.
Mr. Chairman, the motion on the floor is Mr. Mullenhour's, the one that you've seconded. If that fails or if that's withdrawn, then you're back to the legal team's recommendation.
Okay. Mr. Mullenhour.
Sure. Thank you. Just to briefly address comments from Dr. Maxwell, the document that you were referring to, that would have been the investigator's statement. I agree with that. It happens to also be the elements of the crime to which the defendant pled guilty. So essentially, it was this investigator's words, and he pled guilty and said, yes, I did that.
Mr. Holt.
Sorry, just another quick question. And I guess to put kind of my thoughts on the table, I guess I'm uncomfortable with the full revocation without knowing more about whether we have revoked license, and maybe it should be more than 6 months suspension, but whether we have revoked licenses for this type of conduct. Let's set aside whether it happened or not. Let's just assume that we had a video and we all agreed that it was something worthy of pleading guilty to. If that were the case and it was the type of conduct that he has pled guilty to, then are there examples of us revoking a teacher's license in the past for that conduct?
I can't say definitively, but I would just I would say that we would probably do whatever the criminal court did in that case. So if they gave him 2 years of probation, we'd give him 2 years. 2-year suspension is probably what we would have done. There are instances where, as a requirement of the plea deal, they require them to surrender their license. So in those cases, we comply and we revoke the license in those cases.
So I guess there could be instances, and maybe there have been, of inappropriate contact between, it's tough because there are obviously grades of inappropriate contact, but things happening in public, hugging, these sorts of touching where we have revoked teaching licenses before.
Yes, but I would say it would be a more cumulative issue rather than the one instance that's before you. It would have been a compilation of issues.
Okay. Thank you.
Mr. Wells.
So we've been through this before, so I should know this, but so let's say that Mr. Mullenhour's motion prevails, and so the situation we're in right now is he says he's not coming back. So if we were to, if that motion prevails, 5 years, 6 years from now, he decides he would like to be a teacher again. Is there an avenue for appeal to come back to us? And, Mr. Chairman, I asked that question because in that situation, if he cared that much about coming back and felt and his mind has changed, I mean, he might could come before us and we could get more details. I'm just not comfortable with, the evidence that we have in front of us to make a decision, one, for the students, and also a man's livelihood at the same time. So I know that's what we're all torn about, and it's probably common sense that I say that out loud, but just wondering if there is another avenue.
Yeah, so if we were to revoke his license, the period is 5 years. It'll be revoked for 5 years. After that time period expires, he can come back and apply for restoration of his license. When someone applies for restoration, it does come back before you to vote on that, and it's on him he carries the burden of proof. He has to show that, there's been rehabilitation or that the cause for revocation no longer exists.
Further questions, comments? We have a motion and a second on the floor. Ms. Griffin, please call the roll.
Mr. Cobbins.
Aye.
Mr. Holt.
Nay.
Mr. Jensen.
No.
Ms. Johnson.
Nay.
Ms. Maxwell.
Nay.
Ms. McInturf.
Nay.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, the nays have it.
So the motion does not carry. Pardon?
Nathan just asked me the number. 5 nays to 4 yays.
Okay. So the motion fails. We're back to where we have to take action. I would like to see longer than 6 months myself, and also require a person to come back to this board for approval. No, I'm giving my ideas. I'm going to let somebody else make a motion that can put that in words, but that's what
I'd
what
like
I
to
would.
put that in the form of a motion. I would also just, that it's clear that there are expectations that before you come back, that those are completed, and that it comes back to this board for review and approval.
Could we ask our legal team to come up with a recommendation based on that, that we would deal with at our next board meeting? Does that make sense?
Mr. Chairman?
Yeah, Mr. Mullenhour.
From a legal perspective, my understanding is that his current probation ends in October. So his current, the probation following the criminal proceedings ends in October.
November.
November, ends in November, okay. And then secondly, are we able to, is there a mechanism by which an individual applicant can be required to come before this board to answer questions should they decide to apply for a license. Is that something that we can actually effectuate?
I don't think so. Under our rule, an individual that was suspended after that period has run, assuming that they've met the conditions, the professional development, then the rule says that their license is automatically reinstated.
That's great, Jay. Ms. Johnson?
With it just stating professional development, is there a way that it could be correlated with certain number of hours or certain number of courses or something like that?
Yes, we can specify hours, particular courses, or particular subject matter.
Okay. That would be my recommendation, is to have a certain number of hours of professional development tied with this.
I think with Mr. Mullenhour's suggestion too, with regard to the timing on this, is it sounds like something that we need to do at this meeting, as opposed to wait until November at the same time that his term ends.
Mr. Chairman?
Mr. Mullenhour?
It's further my understanding that in the event that we make a decision today, that would still have to be Mr. Dalton would still have time to review that and to decide whether or not to agree to that, and there would be an appeal period after that. Todd, can you kind of walk us through that timeline?
That's correct. So if we were to alter the recommendation today, he would get due process rights on that recommendation as well. So what that looks like is he'll have 45 days to either consent to that new recommendation or exercise his due process and request a hearing on the matter. So as you indicated, his probation does end in November 4th to be exact. So prior to this board meeting again, his probation will be over.
What is a typical number of hours a person has in professional development a year?
I don't know the answer to that question, but
Somebody from TDOE, can you answer that question? Ms. Taylor Reed?
Good morning, Taylor Reed, Senior Director of Licensure. I'm sorry, Chairman Eby, would you mind repeating the last part of the question?
How many hours of professional development are required of a typical teacher in a year? I'm just trying to get a perspective.
Absolutely, thank you for that. So there is no state annual requirement. There is requirements within the validity period of a license. So a practitioner license which is 3 years in validity, would be 30 credits. A professional license, which is 10 years in validity, is 60 credits or hours. However, there are some, it is a local LEA decision if they would like to have local requirements. So we are aware that there are some LEAs that choose to have their teachers participate in professional development that must be logged annually in a certain number of hours. For example, Sumner County, I know, at least a few years ago, I was aware that they were requiring 30 hours of annual training.
So for this situation, I will make a motion, and then y'all can tell me if this is ridiculous or not. I'm going to move that the suspension be for 3 years, which is 6 months times 5 would be 3 years, and 50 hours of training during that period of time. Is there a second?
Second.
There's a second. Are there discussions? And I'm open to amendments if people think that makes sense.
Mr. Chairman?
Mr. Mullenhour?
From a technical perspective, is that motion one that could be implemented?
could you say it again? I know you had 6 months.
3-year suspension and 50 hours of professional development associated with in-classroom behavior.
Yes.
Mr. Wells?
Okay, so if that motion prevails, so what will be the process for him to come, after 3 years, what will that look like? And then 50 hours, and then is it automatic or applies? Does it come back before us? What does that look like?
After 3 years and his completion of the 50 hours, it's automatically reinstated.
Alex Anderson, Associate Counsel for the Board. Just wanted to bring up, Chairman Eby, if it's 50 hours in one particular topic, So that might be setting a standard that would be unachievable, because the spectrum of professional development, and I defer to Ms. Reed, but they receive professional development in everything from classroom tactics to teaching tactics, all the way to how to interact with, and Ms. McInturf probably also knows, being a teacher herself, but it might be hard to find 50 hours of one particular topic that is not duplicative of one another.
It also might make him think about whether he wants to do it or not.
Absolutely. I just wanted to bring that up.
I appreciate that. Ms. McInturf.
You had asked earlier about training for teachers for this situation, and yes, we do have the teacher code of ethics, but it's a 2-page document. It's not, I mean, it's one sentence, right? I mean, so in this situation, or the situations we've seen a lot in this cycle, number 2, the educator shall not unreasonably restrain the student from independent action or in the pursuit of learning. And there's a couple other ones that pertain to it, but it's not really training. I was counting all the number of improper restraints that we're having to look at today, and I really think we need to do something as a board, have a policy for the handle with care training. I know we've talked about this before, and we can't make a district do something that costs money, but I don't think it would be that, the cost would be that much if you have a trained trainer on your staff already. So something like that, because I know there's no amount of training if someone's wanting to be intentionally unethical. Like, there's nothing that we can do. We've talked about this before. But if they are getting in trouble for improper restraints and they haven't been trained in that way, I think that's on us. Like, we need to make sure that we're doing a better job of getting that out there, that there are programs that train teachers how to react in a really hard situation.
Well said. Thank you. Other questions? Ms. Johnson.
I just want to reiterate what he said. For this particular case, the professional development, putting that many hours for the topic that he has been charged with, it is unattainable. That's not a requirement that could be fulfilled. And so I would want to amend that to 3-year suspension with professional development.
Well, I could say that professional development is what Ms. McInturf just said. You read one sentence and that's professional development. I mean, I think there ought to be some
course
specific requirement for professional development, is my feeling. So I'm not going to accept your amendment at this point in time, but if it gets changed, I very well may. What would be a reasonable professional development hours specified, Ms. Reed?
I will say that the professional development kind of scope in policy, it falls within licensure policy 5.502 and then defers to department guidance. It is broad. It is related to educator effectiveness and improving educator effectiveness. Training like this would be fall within that scope, obviously. I will say that being that the policy and then the guidance is rather broad and broad in scope, there are quite a few options to educators. Obviously, my team would work with the SBE discipline team and Todd and folks in ensuring that those hours are met. I will say this is an area that, kind of we go back and forth and collaborate on a lot, but there are a lot of free options out there. For example, this is not related to exactly that, but our Tennessee Literacy Success Act training it's 30 hours. That's what an educator receives. Doesn't necessarily mean it takes them 30 hours to complete. Of course, that's just per the individual user. So I do believe in a period of 3 years that 50 hours is attainable. I think there's a lot of options out there and not necessarily of cost. So that would be, if we think about the validity period of the professional license used to be 6 years and they had to have 60 hours within then, this doesn't fall far outside of that scope.
Thank you. Vice Chair Cobbins.
It's a question for our legal. I know in instances where there have been infractions related to substance abuse or other matters of that nature, we have required some clinical therapy or some other things of that nature. So I'm wondering if there's an opportunity to, professional development is one thing, but there's seems to be something else here that might need to be addressed. And if we can sort of add on to that some aspect of number of hours or therapy or a sign off from, licensed clinical professional that, that would make me comfortable with the 3-year situation.
Mr. Wells?
And that's really a question for you all that
Of whether
in
you can-
instances that has been appropriate in some instances.
Yeah, I think there's been times in the past where we've required, and I've seen other states require an assessment be done, and like you said, a sign off from a clinical provider. So that is a potential option.
Mr. Wells?
So I don't know where we're going to end up on this motion, but I guess I'm going to explain where I'm going to be, where it is as of right now. I don't think I can get comfortable voting for anything that doesn't have him coming back before us before he teaches again. I'm just not comfortable with the evidence that we have to take that risk personally. I agree with Mr. Mollenauer on, the video that I'm seeing. It does not seem egregious. As a parent, I don't think I would be too worried. But there may be something else out there with him, agreeing to it. And then I will tell you, there's something in the back of my mind that it did seem to be one young lady that was in the video over and over, which gives me some, pause for grooming issues there. I thought I saw more than hugging in one instance, or maybe like a hair pull or something. And I just don't think I could ever. I will be voting no on anything that doesn't have him coming before us if he wants to teach again. I think us or a later body of people like us need to decide that. So that's going to be where I vote.
I appreciate that, Mr. Wells. Let me ask our attorneys, is that an option? I don't think under our rules that's an option, is it?
Well, in reading the rule, it says that a suspended license is automatically reinstated provided the individual has presented proof of compliance with all terms and conditions prescribed by the board. So I think you could read that as, you can put that as a condition.
Require him to come before the board?
Yeah. And I think we would need specific instruction as to the reasoning why what he needs to provide to you, as far as, making that a condition of the order.
Mr. Chairman.
Mr. Mollenauer.
Would it be acceptable, Todd, for example, to require that he comes before the sitting State Board of Education at the time, whoever that may be, and that he provides all evidence that was included in the criminal investigation? Like, does he have access to that? Because that's the, again, I'll go back to the term dissonance. I'm assuming that we have only a limited scope of the evidence and that there is something else out there. Could we require that he brings that to this board as a condition?
I'm not sure what he would be able to provide. I mean, in 3 years, this is an offense that's eligible for expungement, so all that stuff could be destroyed at that point. And also we're assuming that there is additional evidence. As far as we're aware of, there's not anything additional than what we've been provided directly from the district attorney's office.
So at minimum, perhaps he could be required to show up in person to answer questions?
Yes, and provide his own his own statement and reasoning behind what happened.
So just to put to connect the dots, for example, a 3-year suspension could be imposed, and that suspension reinstatement would be subject to him showing up in person to answer questions. That would be the conditions of the suspension. Is that technically doable?
I would think so. I don't know if our general counsel has further guidance on that.
I don't. I echo, everything that's been said thus far. I did just want to reiterate that there is not, based on the conversations we've had, any additional evidence aside from the videos that you've seen today. So I just want to make sure we're clear on expectations. But I don't want, for anyone to think that we might have additional evidence, and then you can make the recommendation based on any additional evidence. So I would encourage folks to make their recommendation and their decision based on the video presented to you today.
Mr. Mullenhour and Mr. Wells, I understand what you're saying and generally agree with what you're saying, but I would want to also include the training hours in that, 50 hours of training. And I think Vice Chair Cobbins may have a request to add on to that. Vice Chair.
Well, I would like to, I guess, move to amend the motion that's on the floor to include a clinical assessment and written confirmation from a licensed clinical professional in addition to the professional development hour requirements.
And I will accept that amendment. So does it require a second, Mr. Parliamentarian? I accept that amendment.
If what you could do is simply restate your motion, including what he said, so you could withdraw the original motion and incorporate his.
And we also may want to incorporate a motion from Mr. Wells or Mr. Mullenhour about
All right. Yes, so, I would move to amend the motion as well to add that for him to get his license reinstated, he would have to come before this body.
I would suggest, Mr. Chairman, that you withdraw your original motion and then restate it, incorporating what you're okay with, and then the members could vote on that if.
Just for efficiency perspective, before we restate all of it and then move on it, I assume that would be come before the board again and then would require the board's approval, consent and approval. It wouldn't just be he shows up and it's a clown show and everybody wishes that he's not getting a license, and yet the way that the agreement with him has been written says that he gets his license. I just want to make sure that.
It's always good to have a lawyer, right? Like that would be my assumption, but you're right. That definitely, that would need to be put in there.
Let me ask, is that permissible under the rules? In other words, it's not, because the others, if he just met the time, he automatically got approval, but we could say that the board would vote at that point in time for his approval. Is that okay?
I think so. I think that's okay.
All right, so I'm going to remove my original motion.
Withdraw. Yes, sir.
Y'all help me with this. I'm going to move that he be suspended for 3 years. Pending, during that 3-year period, he comes back and he demonstrates that he's had 50 hours of training with a focus on in-classroom training, that he also has a clinical review with the written statements that says that he has satisfactorily passed that clinical review from a licensed clinician, and that he then appears to the Board of Education, the board that at that point in time presents documentation that he's met these requirements, and that the board then would vote on whether to reinstate his license or not. That's my motion. Is there a second?
Can I clarify one thing about your motion real quick? Earlier you had said you wanted to do 6 months per count, which 5 counts.
Well, that's how I got 3 years.
Yeah, but it's 2.5, 6 months for 30 months.
Oh, 30, I want to do 3 years. I'm sorry.
Okay.
Yeah, thank you. I need math training.
Second.
We have a motion and a second. Is there further discussion? Mr. Griffin? Oh, Ms. Johnson.
I'm still having a difficult time with the 50 hours of professional development. If you are wanting the development and professionalism to be in the area that he has been accused of violating, just saying 50 hours of professional development opens the spectrum. Well, like she said, for literacy.
I said focus on classroom.
But there's not 50 hours of professional development.
I thought I
in
heard her say that she could do that.
No, she said there's hours for professional development, but not specifically on, inappropriate touching or that type of thing. I feel the clinical
Ms.
is
Reed.
more appropriate.
Ms. Reed.
Yes, apologies if I was not clear. I was providing the literacy just as a kind of measurement, if you will, of that particular training is 30 hours, so that the 50 would not, it seems that it's not unattainable, or does not appear that way. While I cannot speak to everything that is out in the world, what I was referencing was licensure policy 5.502 and then our department guidance, in that we do have a large and a broad scope, and so that there's not a particular website or training platform that an educator has to use. In fact, it's really open, and because the policy is broad, although this would be targeted to the areas that are in question, it's not like that educator can only go to one or two places to receive that professional development. They could go to a variety of places. So I believe it's hard to pinpoint exactly how much is out there, but that there are a lot of options, many of which are free, and we actually encourage educators to seek free options when they're doing something as renewing their license or something like that also requires professional development. So I would not be able to provide an exact, hour amount that is available, but we do know that there are lots of free options. We do not have any requirements as far as where those hours must come from, but we do have some recommendations, speaking specifically for a local offering would be the IRIS modules through Vanderbilt. And so it would just depend on where that individual sought those hours from, and then of course they would have to be related to the area.
So you believe that the 50 hours focused on in-classroom is possible?
I would say, in my professional opinion, at best, that it would be possible, yes, especially given the time that has been put before. And I believe the hours are attainable, and the content in those hours is also attainable. And I say that based in the fact that there are lots of options out there, and that the educator would not be, as proposed here, would not be limited to must be through this provider or something like that. Then that would be a different story if that were the case. We'd have to look at those.
Yeah. Thank you. Mr. Jensen?
I just had a comment, and not to, that continuing education, I'm in commercial real estate business, and we're required in one of the states to take an ethics course every year, and it's the same course. And I think that just underscores the importance that the real estate commission see in making sure you're thinking about, it's the same course. So while 50 hours is hard, perhaps, it's also, doesn't hurt that gets trained again. I'm sure legal counsel, same thing. You probably have similar requirements on an annual basis.
15 hours a year I was just looking it up for doctors in Tennessee. It's 40 hours every 2 years. So 50 and 3 seems to be in line with other professions of what's just expected. Now, that's across a wide spectrum of different types of things, but here there's obviously an area of focus that is needed. So,
Ms. Maxwell?
So I don't disagree with the professional training, because I'll tell you, every time I see the teacher licensure discipline report, it upsets me, because we're dealing with our students. So, I really hope that this decreases as time goes on. I think the question here is, having come from being a professional development coordinator at a district, finding specifically topics related to this situation, and that's the onus on Mr. Dalton to find. I think this broadens an area of focus that we need to maybe look at, to say, we need more resources to help support educators so that they do not make poor choices. So I think this is, unfortunate, extremely unfortunate situation. But I think this is a springboard for us to look at because it is, like I said, this is going to be on him to find. But we are lacking resources in this area, in my opinion.
That's a very good point. I think if nothing else, too, this opens up where we are lacking in an area that's very, very important, and encourage the department, encourage our own policies, encourage the districts to look at this as a focus area. Any further comments? We have a motion and a second. Mr. Griffin, please call the roll.
Mr. Chairman, I recommend restating the motion.
You're challenging me. Okay. I moved that we change the suspension to 3 years. And during that 3-year period, 50 hours of training with a focus on in-classroom behavior. That during that 3 years, he will also, Mr. Dalton will also go to a clinician, a licensed clinician, and be appropriately evaluated. Have the recommendation from that clinician. It'll be brought to us at a subsequent board meeting after 3 years from this point in time, where the sitting board at that point in time will evaluate all the data that is presented to him, and then we'll make a judgment on whether to reinstate the license or not. That pretty well said. Okay. Mr. Griffin, please call the roll.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Nay.
Ms. Maxwell.
Aye.
Ms. McInturf.
Nay.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 7 ayes, 2 nays. The ayes have it.
The motion passes. I think this discussion just shows again how this board, takes seriously all of our responsibilities, and I thought it was an excellent discussion. Next, we'd move to items on first reading. It's 10:30. Let's take a 10-minute break. 1 minute, 1 minute.
Sarah's headed out.
Yeah, her dad's dying. She was telling me this morning, doesn't sound good. I think she's hoping she'll get there before he passes, but I'm not sure she will.
How long is the drive up there from here?
It's like 2.5 hours, I think.
She might make it.
Hello.
Got another updated public comment list for you.
Oh,
With one more addition, if that's all right.
All right.
Another leave request
all right,
from a student,
all right.
Emma Hatcher.
She from the same
down at the
school?
bottom. Yes, she's with this group as well.
That's
And
fine.
she spoke at our rulemaking hearing too.
Okay, all right, all right.
Just wanted to let you know.
Thank you. Hey, Rachel, should I do them all together and then him, or should I go in the order?
See, it's up to you.
I think I'm gonna do them all together
That's fine.
and then have him, because they're all gonna say the same thing. So. All right. Let's reconvene. Board members.
My wife just said it made me mean.
Lost control. We are reconvening. Everybody, please take their seats.
Oh, yeah, oh, yeah, oh, yeah, yeah.
Next item is actions items on first reading. Leave for teachers rule, Ms. Lee Hardis. Yeah. Losing control. Go ahead, Ms. Harless.
Thank you. Good morning again. Lexi Harless, Policy and Research Analyst with the State Department of Education. The State Board Leave for Teachers Rule 0520-0102.04 outlines requirements for teacher leave and substitute teachers. Chapters 296 and 235 of the Public Acts of 2025 increases from 20 to 30 days the maximum number of consecutive days a substitute teacher may substitute for a regular teacher on leave without having to possess a teaching license or permit. This item updates language within the rule to cross-reference requirements set in law. This revision is done to minimize the need for future revisions to the rule as potential legislative amendments occur while continuing to meet statutory requirements. And with that, I'm happy to answer any questions.
Is there a recommendation for a motion?
Yes. Yes.
We have a recommendation for a motion on leave for teachers rule 0520-010204. Is there a motion to accept?
So moved.
Vice Chair Collins moves. Is there a second? Mr. Jensen seconds. Are there any discussions or question items for Ms. Harless? No questions. All in favor then for accepting leave for teachers rule 0520-010204 on first reading signify by saying aye. Aye. Opposed? Motion carries. Thank you.
Thank you.
Next item is Educator Evaluation Policy 5201. Ms. Amy Floody.
Good morning, Chairman Eby and members of the board. I'm Amy Floyd, the Senior Director of Educator Effectiveness, presenting for the department. The State Board of Educator Policy 5.201 further defines State Board Rule of Education Evaluations, Rule 05200201. This item updates language within the policy to align with recent changes in the law. Chapter 85 of the Public Acts of 2025 provided further clarity regarding the use of the Tennessee Universal Reading Screener or a Universal Reading Screener approved by the State Board as an approved alternative growth model to generate individual growth scores for pre-K through second grade teachers. Specifically, the law specifies that if an LEA or public charter school administers an approved reading screener for pre-K students, then the LEA or public charter must allow the pre-K teacher to use the results of the screener as an approved alternative growth model. This item updates the policy to cross-reference these statutory requirements. The Department of Education recommends acceptance of this item on first reading. The State Board staff concurs with this recommendation.
We have a recommendation for Educator Evaluation Policy 5201. Is there a motion to accept that recommendation? Vice Chair Cobbins moves. Is there a second? Mr. Holt seconds. Are there any questions for Ms. Floyd? No questions. All in favor then for accepting Educator Evaluation Policy 5201 signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Floyd. Next item is Educator Licensure Permanent Rules 052, 002, 03, 02, 07, 11, 12, and 13. Ms. Taylor Reed.
Good morning again. Taylor Reed, Senior Director of Licensure for the Department. Tennessee State Board of Education Educator Licensure Rules 0520-02-03 outline the license types issued in Tennessee and pathways towards licensure. Rule .02 outlines the different types of educator licenses. Rule .07 governs the issuance of post-secondary licenses. Rules .11 through .13 outline the requirements and issuance of endorsements, permits, and limited licenses. Chapter 328 of the Public Acts of 2025, or PC 328, took effect on July 1st, 2025, and made various revisions to educator licensure laws. This item makes corresponding revisions to various sections of the educator licensure rule to align with PC 328, including added the limited occupational teaching license to eligible license types and defines its validity along with that of the limited academic license, allows additional endorsements on subsequent post-secondary educator license issuances, removes prohibition on courses with end-of-course exams and elementary physical education for emergency credentials and limited licenses, eliminates outdated occupational permit requirements, which have been replaced by the limited occupational teaching license, and establishes and updates criteria for issuing, renewing, and advancing the limited academic and limited occupational teaching licenses. State Board staff will hold a rulemaking hearing to collect public feedback between first and final reading on the permanent rule. This item is also being proposed as an emergency rule at this board meeting to ensure that the rules are in place for the start of the 2025-2026 school year and meet the public chapter's effective date. The Department of Education recommends acceptance of this item on first reading. The SBE staff concurs with this recommendation, and I'm happy to take any questions.
We have a recommendation for Educator Licensure Rules 0520, 02, 03, 02, 07, 11, 12, and 13. Is there a motion to accept on first reading those recommendations? So moved. Mr. Wells moves. Is there a second? Ms. Johnson seconds. Are there any questions for Ms. Reed? No questions? Oh, I'm sorry, Ms. McIntyre.
I may have missed it, but there's nothing about the middle school requirement now for the 90 minutes a week. Is there some information we need to make sure districts, what? We're on the PE. Sorry, I'm the wrong one. That'll be for the next one.
We all do that, don't worry. Any other comments or questions for Ms. Reed? All in favor then for accepting educator licensure permanent rules 0520, 02, 03, 02, 07, 11, 12, and 13 signify by saying aye. Aye. Opposed? Motion carries. Thank you. Next item, Literacy and Specialty Area Standards for Educating Preparation Policy 5.505. Dr. Jennifer Nelson.
Good morning. Jennifer Nelson, Senior Director of Educator Preparation. The Tennessee State Board of Education Literacy and Specialty Area Standards Policy 5.505 outlines the literacy and specialty area standards for all approved programs that lead to licensure. This item proposes that approved programs in integrated early childhood education may recommend candidates for licensure in integrated, general education, or special education early childhood if candidates have qualifying scores on the required assessments. The proposed change mitigates potential challenges in staffing educators in high-need areas by ensuring continued access to options for licensure with endorsements that were previously set to retire, allowing state board-approved candidates to be recommended for these endorsements on the basis of completion of an integrated endorsement program and submitting qualifying scores on required assessments, ensures consistent requirements across all candidates types, and ensures consistent mechanisms for licensure recommendation processing. The Department of Education recommends acceptance of this item on first reading, and the State Board staff concurs with this recommendation.
We have a recommendation on literacy and specialty area standards for education preparation policy 5.505. Is there a motion to accept that recommendation?
So move.
Ms. Maxwell moves. Is there a second? Second. Mr. Holt seconds. Are there any questions? No questions. All in favor then for accepting literacy and specialty area standards for educator preparation policy 5.505 signify by saying aye. Aye. Opposed? Motion carries. Thank you. Next item, physical education, physical activity policy. Ms. Lori Paisley.
Good morning, Mr. Chairman and members of the board. I am Lori Paisley, Assistant Commissioner of the Division of Coordinated School Health, and I'm here to present an item on the physical education and physical activity policy. This item updates language within the physical education and physical activity policy to align with state law and other policy. Chapter 306 of the Public Acts of 2025 increases from 130 minutes per full school week to 40 minutes per school day, the minimum amount of physical activity required for elementary school students. The legislation also establishes additional requirements for the minimum amount of physical activity required for elementary school students. Because state law outlines minimum amounts and requirements of physical activity for elementary school students, the department recommends removing redundant language from policy and prioritizing detailed guidelines necessary to interpret state law. Further revisions were made to this policy to remove the sections of the policy related to the School Health Advisory Council and the School Health Index from the physical education and physical activity policy. The requirements for the School Health Advisory Council and the School Health Index are included in the Coordinated School Health Program Policy 4.204, and the sections are being removed from the physical education and physical activity policy to avoid duplication across state board policies. Additionally, the item provides clarity on required school and district practices related to student physical activity and physical education by streamlining language used throughout the policy. The Department of Education recommends acceptance of this item on first reading, and the State Board staff concurs with this recommendation. I'm happy to take any questions.
We have a recommendation for physical education and physical activity policy 4.206. There's a motion to accept the recommended policy. Second? Was there a motion? Who made the motion? Oh, Mr. Jensen moves. Is there a second? Ms. Johnson seconds. Now, Ms. McIntyre.
Thank you, sorry. Are there any changes or policy for middle school that districts need to be aware of? Because I know it was in the law as well, that needs to be 90 minutes per week. Any guidance that I can bring back to my districts?
I think you're asking about physical education,
Yes.
and that is something that gets confusing for people. This change is about physical activity, so the new state law is about physical activity minutes during the day for elementary students. So that didn't change physical education.
So, but if a student does not have PE during the week at all, they're still going to have that in some sort of physical activity minute, correct?
The same amount of middle school minutes that were previously in law. Nothing changed with this.
Okay, all right. And then I had another question where it says weather permitting. So it is okay to not have 40 full, free, unstructured playtime minutes if it's like last week it was a monsoon pouring down rain. And it would be very hard for teachers to have to do inside recess for free play for 40 minutes when they can't go outside.
Correct, and that's a local decision.
Okay.
Here in Tennessee, we have some pretty harsh winters, and my former district, our students couldn't go outside unless it was 40 degrees or above, but that varies from district to district. But as you pointed out, when it's a monsoon, you can't necessarily take students outside. But teachers have become very creative on getting kids physically active throughout the school day in their classrooms.
So that can be a local decision?
Correct.
Okay, perfect. All right, thank you.
There was, Mr. Jensen,
I
go
was
ahead.
just curious, could I express my ignorance? That's easy to do, and get a definition of physical activity.
Physical activity is any movement. So if a teacher or a school with their scheduling has incorporated 5 minutes of physical activity in each class or throughout the school day, that is walking. One thing that has been successful here in Tennessee that I'd like to share is Go Noodle. Go Noodle is a company that is based right here in Nashville that is worldwide, and they've worked really closely with teachers and with us to incorporate using whiteboards, much like you see here today, and it incorporates the lessons so they can incorporate the math that third graders are learning with physical activity. So it really varies. It can be walking, it can be just standing up and doing jumping jacks by your desk. It's just movement.
But to be clear, it is not walking from one classroom to
No,
the
it
next
is not.
classroom.
Thank you,
That
Mr. Eby.
specifically is pointed out.
Yes, it is walking, but not walking from class to class.
Okay.
I do have one question, because there was one area where you did impact physical education. And item number 5, the words are strongly encouraged. LEAs, we had previously, are strongly encouraged to provide physical education at least twice per week to all middle and high school students. And that wording was now changed to may provide physical education at least twice per week to all middle school and high school students. This board specifically had those words strongly encouraged in there before because of the importance that we believe that. And so I guess what I would like to see, if this board agrees, is that that language be changed back to strongly encouraged. Was there a reason for that?
Robin and I discussed that, and we discussed that with Michael, I believe, and we are going to talk with you about that between first and final reading, but I don't have a problem with that.
Okay. Thank you. Other comments or questions? So we have a recommendation for physical education, physical activity policy 4206 on first reading. All in favor signify by saying aye. Aye. Opposed? Motion carries.
Thank you.
Next is career and technical education standards. Ms. Deborah Knoll.
Good morning. I am Deborah Knoll, Assistant Commissioner of Post-Secondary, Workforce, CTE, and Military Readiness. I'm presenting this morning on the Career and Technical Education Course Standards on first reading. This item includes revised course standards for the following CTE career clusters: Healthcare and Human Services, and Middle School Career Awareness, Career Exploration, and Career Advising in Planning. This item also includes a new program of study, Technology and Production Agriculture, for the Agriculture CTE Career Cluster. 2 new courses are included in that program of study: Agri-Science Technologies and Precision Agriculture. The CTE courses have been updated and created based on educator feedback to align more closely with industry and post-secondary needs. Industry partners and secondary and post-secondary educators have reviewed these new and revised standards. The nursing education course has been updated to better align with industry-recognized credentialing terminology and certification requirements. The middle school career course standards have been updated to improve alignment with current state policies and provide students with clear, more relevant career preparation pathways. The terminology has also been updated in these courses to reflect policy and programmatic changes. Additionally, the academic plan is now referred to as the High School and Beyond Plan, with added detail to help students understand its purpose in connection to future planning. This change brings the course into alignment with the state's middle grades and high school policy, ensuring consistency in language and intent across all grade levels. We've also created 2 new agriculture courses for the new Technology and Production Agriculture program of study. Agri-Science Technologies is an applied science course that focuses on the use of scientific methods and data analysis to solve real-world problems. Through practical application, students will gain insight into how science and technology can enhance agriculture practices and contribute to sustainable resource management. Precision Agriculture is an applied course that addresses the technological innovation in agriculture that thrives on new advances, sustainable practices, and secures future farms and farming communities. Upon completion of this course, students will have learned the basis of computer and data science in the agriculture industry. Additional feedback will be solicited between first and final reading. The Department of Education recommends acceptance of this item on first reading, and the State Board Education staff concurs with this recommendation.
Thank you. We have a recommendation on career and technical education standards. Is there a motion for acceptance?
So moved.
Mr. Jensen moves.
Second.
Mr. Wells seconds. Are there questions?
I do have a couple of things.
Yeah, Mr. Jensen.
Is your curriculum, where is it coming from? Is it ICEB, or you're developing it, or it's on those agricultural courses?
That's a great question. So it is our job at the Tennessee Department of Education to create standards, which are the foundation to these courses. It is an LEA's decision to use what curriculum they want as long as it aligns to the courses. They can, and it can go above and beyond our coursework or our course standards, but that foundation piece is what we establish.
And are you processing this in a way for dual enrollment? Is that a consideration in this?
So when we create course standards, oftentimes there are aligned dual enrollment opportunities. We ensure that we have a seamless progression from middle school through our secondary space into post-secondary, which oftentimes does include those dual enrollment opportunities.
Okay. I would just observe, Mr. Chairman, the agricultural industry in this state is $110 billion a year. And the next closest industry vertical is tourism at $30 billion. And I just think this is great that you're doing this. And we just, you know, it's a huge part of our economy in the state, and we really need to make sure we're focusing on developing that. And of course, the CTE route for a lot of people is very, very important. And our higher education also, we've got folks that are hopefully expanding those opportunities. But I really appreciate the direction that you're taking, and I think it serves our the students in our state. Thank you.
Mr. Wells.
I just want to say ditto. This is very exciting. My district's very, very rural, and the county I live in is the #1 agriculture county in the state, with poultry, equestrian, and beef. So this is very exciting. Thank you.
I say triple. No, I went through and read the standards for the agriculture courses, and I mean, they're outstanding. You talk about learning durable skills and critical thinking skills and real life skills and preparing for post-secondary. It was very good. And then I saw AI in agriculture. I mean, I think that could be very interesting too. So glad that we're able to offer our students the opportunities to take courses like this to prepare them for their career paths. Thank you.
You got one more.
Yeah. Mr. Cobbins.
I'll say quattro. No, I was just, that conversation was just making me think about a day in the district we did in Tipton County a couple of years ago, and toured their CTE programs, and they have a digital agronomy program. And seeing those students use technology in that way was really, really informative. So to Mr. Jensen and Mr. Wells and Mr. Eby's points, I think we're on the right track. Thank you.
Continue to expand those CTE classes. That's great.
Will do.
Yes.
Since everyone's chimed in, I thought it would be a good time to jump in as well. This work, I think, is really important, and one of the things that I'm really glad to see is that our TCATs, our Tennessee Colleges of Applied Technology, where some of this work is happening, are actually partnering really well with our four-year institutions and making sure that those credits can indeed transfer to a four-year institution. It's having to be done one by one. It's not a fast process. It's a difficult process because of the accreditors that are involved, but it's happening, and we're really, really excited about that. And it's through the really strong CTE pathways that we have.
Thank you. Any further comments or questions? We have a recommendation then for career and technical standards. All in favor signify, a motion and a second. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Null. Next item, course access rule. Ms. Rachel Supay.
Good morning, Mr. Chairman and members of the board. I'm Rachel Supay, General Counsel for the State Board of Education, and I'm presenting on the Course Access Program Rule changes. The Course Access Program Rule 0520-01-14 effectuates the Course Access Program, which is set out in statute at TCA 49-18-101 through 110. Recent legislative changes, specifically Chapter 235 of the Public Acts of 2025, repealed from statute certain program reporting requirements due to minimal district interest in this program over the last several years. The legislation required removal from our rule of the requirement that the Tennessee Department of Education publish a link on their website to a course access catalog. And it also repealed the requirement that the department make certain information about the program publicly available. And those are all enumerated in the cover sheet, the 6 things that are no longer required to be reported by the department. And I am happy to take any questions. And I will note we will host a public rulemaking hearing between first and final on this one.
We have a recommendation for Course Access Rule 05200114, 05, and 07. Is there a motion to accept the recommendation? Vice Chair Cobbins moves. Is there a second? Mr. Holt seconds. Are there questions? I have a question. So I think one of the reasons some of this was repealed was because of the lack of the number of students that were taking it or something. Why is that? I mean, is it just not being advertised? People aren't into virtual classes? What, help me out.
I think there's a number of reasons why we haven't seen a great deal of uptick, and I'm happy to lay out what some of those are. First, I think there's a lot of questions around how an LEA would work to implement this on the ground, and how the funding piece would work. So the host LEA can charge fees for the course, and then the sending LEA, where the student is enrolled, would have to pay any of those fees, I believe, for the first 2 courses. And I think there's been some questions about, what would that lack of funding mean, and how would that look like day to day to pay for those courses. I think there's also a capacity issue, since the LEA would be required to review any proposed courses to make sure they're aligned to academic standards and meet all other curriculum and instructional requirements in the law. And that would, be a lift on the LEAs to review that from the course providers. And I think there's not been a ton of student interest, is my understanding as well.
So if the law that changed basically takes away the requirement that the department tell how many students are taken and what courses there are, how do we know how well or how effective the courses are being and meeting the needs of the students, or what? I mean, I'm just trying to understand the reasoning.
Currently, there are no LEAs who have expressed interest in participating, but a number of years back, there were some course providers who did submit to the department an application to have their courses shared. And so historically, there was information on the department's website about, how to access a course if you so choose. If in the future the board does end up approving any future courses in the course access program, they would still be listed in the general course catalog that's available online. So you would still be able to see any course access programs along with any other courses that a student can take online. This is just repealing the requirement that there be a separate course access program catalog. And
All right.
I have my department colleagues here to correct me if I got any of that incorrect.
All right, well, help me, because I'm a little confused. Maybe I'm getting terminology confused. So when we talk about course access, how is that different than virtual courses that one LEA may offer to students at another LEA? Is that not course access, or is course access something different than that?
I think there can be some overlap. Certainly the course access program was meant to kind of get at expanding a student's, the breadth of the, I think, electives mostly that are available to students. So if there is a very niche course, maybe something very particular that most districts don't offer, but one district does offer it and a student in another district wants to take it, they could try to do it through the course access program. But there are some distinctions on what can be offered in the course access program. So for example, if there's a state mandated assessment that's required for the course, then it could not be as part of the course access program. Whether, if an LEA had a virtual program that was open to students of other districts, that might be a possibility. They might also, charge certain fees associated with that, but that would be up to the LEA whether they wanted to allow students outside of their district to participate.
Thank you. Any other questions? So we have a recommendation for course access rule 0520, 01, 14, 05, and 07 on first reading. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thanks, Ms. Supay. Next item, charter school rules. Ms. Allie Reed.
Good morning, Allie Reed, Director of Engagement and Accountability for the State Board. On first reading this morning is proposed updates to our charter school rules, .01, .03, 04, and 05, which we discussed in greater detail yesterday during the workshop. These rules include the charter application process, charter school funding, enrollment, and reporting requirements. And the proposed edits within each rule are necessitated by recent legislative changes as well as anticipated improvements to fundamental charter school processes. The items cover sheet goes into specific changes within each of the rules in response to both the legislation as well as additional proposed changes, of which engagement with charter school leaders, charter authorizers, and support organizations played a role in informing. I'll also note that the proposed changes, specifically in the funding rule -.03, mirrors those that were approved on emergency rule at the board's special called meeting on July 30th. Our staff will continue to engage stakeholders for further feedback and refinement, as well as hold a rulemaking hearing between first and final reading. Happy to answer any questions.
We have a recommendation on charter school rules 0520, 14, 01, 01, 03, 04, and 05. Is there a motion to accept on first reading?
So moved, Mr. Chair.
Mr. Mullenhour moves. Is there a second? Second. Mr. Holt seconds. Are there any questions?
I do have a question.
Mr. Mullenhour.
Allie, could we just hone in for just a moment on the section that talks about underutilized property?
Sure.
I'm trying to pull up that code section here, but basically my question is, what have we seen since this rule has been out? What has the response been?
So this, to note, nothing has changed in here since we
Right.
last approved it, just was
It's
reorganized.
just been
Yep.
been shifted, yeah.
So authorizers were required, or LEAs were required to post on their websites vacancy reports as of May 1st. And so they are up there. I have not heard anything beyond that, but certainly it is available in information that is not only designed for their current operators, but also for charter applicants. And so I anticipate that there may be some who are planning to apply this next cycle that are utilizing that information that's now available.
And my understanding is that there's also a requirement that this information is compiled and reported to the comptroller.
Yes.
Is that something that we could request from the comptroller? I'd be curious to see that report, just so we don't have to
I'm
try to
sure.
compile that ourselves.
Yeah.
Okay, thank you.
Mr. Jensen,
Question along the same.
your mic's not on.
Oh, there it is. With that list of facilities, that's nice to have a list, but is there any mechanism for causing those properties to be available in a local market? So there's a list of them, right? So, okay, great. So what happens after there's a list?
I think the intent behind it was to provide an avenue for authorizers and both existing operators and potential operators to engage in discussion about use of those facilities, in which the authorizer could opt to rent a space or an entire building to a charter school simply because they're hosting that it is available, and then that allows for that conversation to begin.
I appreciate that, but are the facilities, is there a mechanism to make the facilities available that are surplus or they're sitting empty?
Not that I'm aware of, no.
That concerns me. It's sort of like, okay, tell us what you got, but then you don't have to do anything with it. And I don't know if that's a legislative issue or whatever, but it concerns me because there are properties that are not being used and they're sitting there and they're deteriorating or they get vandalized or whatever, and we simply have to call for a better way, in my mind, on those surplus properties that are, and I'm sure it's in other markets, and I know there's desire for them, and I just think in serving kids that we need to call for something a little more than give us a list and we'll talk to you, maybe. So.
Maybe that's something from our legal office, what rights, what authority do we have versus others?
Sure. Rachel Supay, General Counsel. I'm happy to comment on that a little bit. Ms. Reed is correct that there's nothing in the law that would, force an LEA to lease their vacant or underutilized property. I will say that charter schools do have the first right of refusal if the LEA is not planning to use it. To answer Mr. Jensen's question, it is a little bit, I'd say, dictated by statute, in that the charter school statute does say, nothing in this section is intended to frustrate an LEA's ability to plan for the use, meaning the future use, of any currently underutilized or vacant properties. So I think it would be tricky for a charter school to, how do they go about proving perhaps that an LEA is not going to be, using those properties? So it's something we can certainly explore and have further conversations with our authorizers and charter schools to think through if there is a concern that, properties are not being made available as required by the law.
Mr. Chairman.
Mr. Holt.
So I share Mr. Jensen's concerns on this point. I've actually worked with charter operators in Nashville. I'm aware of them that have tried to invoke the right of first refusal language that exists in law and in our rule. And to Mr. Jensen's point of kind of, we have this information that these facilities aren't utilized, what do we do with it? There, in law and in our rule, there's this right of first refusal ability where if a public charter school notifies the district that there is an underutilized property on the list, then they can send a letter that gives them a right of first refusal, but that only then ripens into anything if the district then takes this property that it's not currently using and doing anything with and decides it wants to sell it to a third party, which if you're not using property, then you're probably not going to sell it to a third party given the sort of financial incentives that exist here. So I'm concerned about, I think I understand the spirit behind it, but as a practical matter, like what is being done? And when you have rights of first refusal that, it's a letter that goes to the district, but then nothing actually comes of it because the district's not going to sell its property in many instances, and therefore the right of first refusal is just a letter that sits on the books. We're not solving this issue of kind of getting the property into its highest and best use for students, for taxpayers, et cetera, in my view. But I would be interested in knowing, what legal capabilities we have as the State Board of Ed within the legislative constraints to make any impact here, and then also look at, what we can do as, for advocacy to the extent that that's what our role is.
Mr. Mullenhour.
I agree with all that. I read this landscape as follows. The legislature saw the importance of putting sunlight on this question, and they put a mechanism in place to require that the data is collected so that presumably primarily they, and maybe we to some extent at the board level, can evaluate the extent to which it is an issue, and then align policy with some understanding of the scale to which this is happening. This is, as I understand, this will be the first cycle where this data will be collected, right? So we only have one data point at this point in time. But I think we do need to understand, like, what is that first read? And are the districts providing the information that's required? And to the extent that they aren't, how do we make sure that we encourage everybody to do that, so that maybe in the next year or two or three, the legislature can evaluate that question and figure out how to best craft at a legislative level an answer to the issue. My concern, the reason I brought it up, is just it is the first cycle, and we need to make sure that we aren't looking back 2 or 3 years from now and then going back to people and saying, oh, we need you to retroactively kind of get us this information. No, we need to make sure that the information is being collected and that it's being compiled properly, and make sure that the legislature has what they need to be able to address this question. So I view Sunlight as the first step.
Mr. Holt?
Unless others have thoughts on the facilities, underutilized facilities point, I had some questions for Ms. Reed just about the changes to the charter school rule. On the first page of the red line, it shows that we've removed the part of the rule about application categories that existed in charter school applications. Could you explain what the reasoning is there?
Yep. So as part of the application redesign that we discussed yesterday, the categories have been removed from the application process, and so we are echoing that here in the rule.
Great. And then there's some changes to the part of our rule about when a charter school application is deemed complete, and then the notifications that might go from an authorizer back to a charter school sponsor about whether it's complete and what the implications of that are. Could you please sort of explain what the changes are that are in our new rule?
Yes, I believe you're referring to paragraph F, which has been updated to really streamline the process that authorizers and charter applicants go through in terms of determining if an application is complete. So with our prior rule, there were multiple steps involved, one of which was checking each section, each question. An authorizer was obligated to do that to state whether or not the application was complete, and it often was creating some tension between the applicant and the authorizer in terms of whether or not they felt something needed to be complete and the other party didn't. And so to eliminate that tension, we have in the proposed changes attempted to streamline that further and simplify what it means to be complete. And so that's what you see in paragraph F, where we are stating that if an application will be considered complete and therefore must be reviewed by the authorizer if the following are received by the deadline specified previously, so that February 1st deadline. And that is the written application, the proposed budget, up to 5 paper copies if requested, and the application fee. So long as those items are received by the deadline, then the authorizer is obligated to review it and move forward with their process.
Great. Thank you. And I just wanted to commend Ms. Reed on the record today for the work that she has been doing as a result of the increased role the State Board of Education has with charter schools as a result of the new law. So, no, we mentioned that yesterday as well with the presentation, but wanted to do that today too.
Thank you.
Thank you. Other questions or comments? We have a recommendation for Charter School Rules 0520, 14, 01, 03, 04, and 05. Motion and second. All in favor signify by saying aye. Aye. Opposed? Motion carries. Next item.
Mr. Chairman, I had a question before we move to the next
Sure.
item.
Go ahead, Mr. Chisholm.
And you are remarkable at reading those 01, 04, 06. I just amazed sometimes. But would it be appropriate, and maybe legal counsel, if we had a committee of this board to look at this going forward on how these surplus properties are being, just so that we're not sitting here, would it be appropriate for us to have a committee that is charged with oversight or something? I'm not sure what.
Yeah, no, I think that's a great idea, at least to lighten us and figure out, is there something that we should be doing, or?
Yep.
Yeah, I think it's.
I'm recommending it if it fits within the you know, what our responsibilities are. It just seems like we have some responsibility on a statewide basis to look at this issue and make sure the properties that have been paid for by the taxpayers are used in a way that benefits the community, the entire community.
Maybe we can have our legal counsel and our parliamentarian look to see, to establish a committee, what it would take to do that.
Mr. Chairman, the chair has the authority to establish a committee, or it could be done by resolution of the board. I would say if OREA is in the process, or this information is being compiled for the first time, for whatever source it may be compiled, it would probably be very helpful to have that initial report so that the committee would have something to study, rather than the potential of having board staff, you know, out in front of some other effort to put that information together.
So when is that, Ms. Reed?
To clarify, there, as far as I'm aware, is not a report that is being compiled. It's rather that authorizers, or LEAs rather, have to post this on their website and submit it both to the department and the comptroller. And so I think a request for that information or going on their website to pull down is pretty simple. But there is not, as far as I'm aware, an actual report that is being produced.
So can we ask you or our staff to request for that information when it comes up? And then we'll take a look at it and decide what's our best appropriate path forward and think about a committee or something like that. So is that fair?
Yes, sir, and it's, yeah, that's well within your prerogative at that point in time.
So
Or
let's
if
do
a
that.
member wanted it, they could ask as they did, or just offer resolution to make it. So,
Do you want to write a resolution? Mr. Holt's good at writing resolutions.
I defer to counsel.
As long as they don't have to go back up on the hill again.
Happy to assist.
Well, let's take a look from a legal standpoint and what it takes to get that information. And then let's, once we have that information, let's decide if we want to have a committee or what we want to write a resolution, or what do we want to do to move this thing.
I just think we need a more active role in this, that we're not waiting for a report to come 3 months from now. And then this is an issue that I think is pretty critical for us to be aware of and to weigh in on.
Understood.
For clarity, Mr. Chairman, the resolution I was referring to is if a member wanted to cause a committee to be created. The easiest way is just to say, hey, Mr. Chairman, would you mind creating a committee? And then you do it. So that was the only resolution I was referring to.
But what I heard was that you wanted to get the information before we formed a committee. And so that's what I think that's what I heard. Ms. Reed?
I was just going to say, it is publicly available. You know, it's on the authoriser's website. So there doesn't necessarily need to be a request. My point in saying that is I think you can establish a committee right now if you would like to.
Okay. Let's establish a committee to look at the information to see what's the best path forward to understand unused facilities. Is that basically what you say, Mr. Jensen? And in that, can we talk about who's going to be on that committee later?
Yeah.
But we can ask Mr. Jensen to chair that committee right now?
Sounded like Mr. Jensen wanted to chair it. That's what I heard.
As long as Mr. Holt joins me, that's fine.
I think there's two members of the committee right there, Mr. Jensen and Mr. Holt, and we will, if somebody wants to volunteer, the third person wants to volunteer, let me know. Otherwise, I will appoint someone later. You want
Next
to
item.
volunteer, Mr.? Oh, Ms. Mullenhour wants to volunteer. So there's our committee. Mr. Jensen, Mr. Holt, and Mr. Mullenhour. Established. Thank you. Next
Thank
item.
you. Okay, thank you. On first reading this morning also is our two charter school policies, 6.111 and 6.113. I will discuss 6.113 next, but both of which are being updated in response to that same legislation we were just speaking about on the charter school rules. The Quality Charter Authorizing Standards Policy contains the essential practices that govern the day-to-day operation of our charter school authorizers in Tennessee, and the standards that authorizers are evaluated against every other year, as part of our authorizer evaluations. The proposed changes to this policy include updating references to state-required documents that have shifted from the Department of Education to the State Board, as well as adding clarifying language and edits that ensure authorizers are not assessed against a similar standard more than once in an evaluation. Happy to answer any questions on this policy.
I have a recommendation for Quality Charter Authorizing Standards Policy 6.111. Is there a motion to accept that recommendation? Vice Chair Collins moves. Is there a second? Ms. McInturf seconds. Any questions? No questions. All in favor for approving on first reading Quality Charter Authorizing Standards Policy 6111 signify by saying aye. Aye. Opposed? Motion carries. Next item is Charter School Authorizing Evaluation Policy 6113.
Thank you. As I was just referencing, this is further following the changes that came from legislation. This item, 6.113, has an appendix. We okay? Yeah. This item has an appendix to it, which is the evaluation rubric, and the standards included in that rubric are the exact same that you just accepted in State Board Policy 6.113. Happy to answer any questions.
Recommendation for approving Charter School Authorizing Evaluation Policy 6113. Is there a motion to accept?
So move.
Ms. Maxwell moves. Is there a second? Ms. Johnson seconds. Are there any questions? All in favor then for accepting on first reading Charter, for accepting Charter School Authorizing Evaluation Policy 6113, signify by saying aye. Aye. Opposed? Motion carries. Next, accountability hearing policies 1600.
Thank you. The next item on first reading is the Accountability Hearings Policy 1.600. This policy is a companion to the Accountability Hearings rules that are on final reading today and provides further explanation of the hearings timeline, appointment of the board's hearing committee, and the corrective actions that the State Board may recommend for the department to impose following a hearing. The State Board's Hearing Committee, we will be appointing at the board's November meeting, and the Hearing Committee will begin holding these hearings during the first quarter of the 2026 calendar year. Our staff engaged stakeholders in the development of this policy, incorporated feedback as appropriate, and will continue to seek additional feedback between first and final reading of the policy. Happy to answer any questions.
I have a recommendation for accountability hearings policy on first reading 1600. Is there a motion to accept that? Mr. Holt moves. Is there a second? Mr. Wells seconds. Are there any questions? I do have one. It's more of a comment than a question. As I read through that, there's 10 days to hear and 5 days to hear, and then it refers to another policy. I think it'd be really helpful visually if we had a timeline laid out that showed all the things that needed to be done in a particular time period. I know I look at that and I look and see how much time these important accountability hearings are going to take. Just planning my schedule would be good to look and see, have it laid out on a timeline if that would be possible.
Yeah, we can absolutely work on a visual for it.
Yeah, great. Any other comments or questions? We have a motion and a second to approve accountability hearings policy 1600. All in favor signify by saying aye. Aye. Opposed? Motion carries. Next item, state approved textbook and instructional materials list, Schedule E for PE, health, and CTE, IT, and advanced manufacturing.
Good morning, Hayden Shadden, Textbook Commission, General Counsel. The Textbook Commission has prepared a preliminary list of textbooks and instructional materials for the Schedule E textbook adoption cycle. TCA 491302 states that it is the duty of the State Board, and the State Board has the power to prescribe the use of textbooks and other instructional materials based on recommendations of the State Textbook Commission for various subjects taught or used in conjunction with public schools. TCA 496-2202 requires the State Textbook Commission to prepare a list of standard editions of textbook and instructional materials for approval by the State Board for use in public schools of the state. The law also provides that the Commission, through its chair, may appoint an advisory panel of expert teachers and other experts in each subject area or grade level to advise the Commission on textbook and instructional material selections. The chair of the Commission led the advisory panel application review between October 2024 and March 2025. During the March 2025 meeting, the commission accepted applications to fill an advisory panel consisting of educators with experience and expertise in various Schedule E subjects. Panelist applications were scored by both the commission and subject matter experts at the department. The commission requested and later approved department-created scoring rubrics for each of the Schedule E subject and/or courses, focusing on 3 categories. First, publishers had to provide a Tennessee Standards Alignment Guide. Second, all material had to cover 100% of the applicable academic standards for that course. And third, materials had to meet an 80% quality threshold outlined by the commission's approved department-created scoring rubric. Those quality indicators were comprised of 3 subcategories: instructional focus, multiple dimensions, and accessibility. Hired panelists attended a 2-day in-person comprehensive training conducted by subject matter experts at the department. This training included discussions and strategies for reviewing and scoring material, and it also highlighted various legal topics. The panelists conducted independent reviews between April 26th and June 27th, 2025. These reports were disseminated to commission members and discussed during the July 30th commission meeting. The commission will meet on September 12th, 2025 to hear publisher appeals and to consider any public comment received as it relates to Schedule E textbook and instructional materials. The commission at that time in September will vote on the final items of the list for Schedule E textbook and instructional materials and determine what to recommend to the state board for your final approval during the November quarterly meeting. This item presents the initial list of textbook and instructional materials recommended by the commission on first reading, and the textbook commission does recommend approval of this item on first reading. I'll be more than happy to answer any questions you might have.
We have a recommendation for state-approved textbooks and instructional material list on Schedule E, PE, Health, CTE, IT, and Advanced Manufacturing. Is a motion to approve this list?
So moved.
Vice Chair Collins moves. Is there a second?
Second.
Ms. Maxwell seconds. Are there any questions or comments? I had one question. I looked at that list, and there was an awful lot that did not pass. Is there any general reason for that, or, and I guess there is an appeals process that they can go in and change their, but it just seemed like a whole lot of them didn't pass the first time.
Yep, great question. So out of the 34 courses up for bid in Schedule E, 33 of those courses are CTE courses. Depending on the CTE subject, at minimum, it has been 7 years since the last scoring and review of CTE material. And so you're looking at a 7-year gap at minimum, up to 13 years last that CTE material has been reviewed and scored. This cycle in Schedule E, we had 7 publishers who submitted bids for various Schedule E material. Out of those 7 publishers, 6 of those publishers have never submitted a bid with the state of Tennessee before. And so out of those publishers, after the initial review and that list that came out in July, a majority of those publishers have indicated that they are willing to correct the material and revise and submit that to the commission. And those publishers do have until August 21st next week to submit that material in the commission. We do believe that a majority of those publishers who had material that failed upon initial review will correct those issues and resubmit it to the commission.
Thank you. Other questions? Let me first thank the Standards Textbook Commission. I mean, it's a lot of work to do what you do, and again, your focus is on the students and, you know, how we can educate them, how we can, particularly in CTE classes, how we can prepare them for post-secondary success. But thank you for your efforts. Now we'll take a vote. All in favor for approving on first reading state-approved textbooks and instructional materials list, Schedule E, PE, Health, and CTE, IT, and Advanced Manufacturing, signify by saying aye. Aye. Opposed? Motion carries. Thank you, sir. We'll now move into action items for final reading. First is Innovative School Districts Rule 05200125. Ms. Robin Ye.
All right, and good morning, board members. Robin Ye with the Tennessee Department of Education, and I'm here to present the Innovative School Districts Chapter 05200125. Chapter 1053 of the Public Acts of 2024 established a new type of local education agency known as an Innovative School District. In Tennessee, state colleges and universities may contract with LEAs to run training schools for grades pre-K through 12 at which the college or university's teacher candidates may gain experience in the classroom. These training schools have been allowable under state law for many years and operate in LEAs across the state. Public Chapter 1053 established a pathway by which public universities that operate these training schools may apply to the department to gain recognition as an innovative school district and operate as an LEA rather than operating under a contract with a separate LEA. And I did want to note that the law also authorized the University of Memphis to be an innovative school district in which they are operating as such currently. This item proposes rules to establish a process by which eligible universities may apply to operate their training schools through an innovative school district, including the submission of a plan comprised of components listed in the public chapter that ensure compliance with federal and state laws, rules, and regulations. The state board staff held a rulemaking hearing on July 24th to collect public feedback. There were no public comments submitted, and there were minor revisions between first and final reading to include clarifying the appeals process to specify that the department will only consider timely filed appeals by public university to become an innovative school district. Department recommends approval of this item on final reading, and the state board staff concurs.
Thank you. We have a recommendation for Innovative School District Rule 05200125. Is there a motion to accept?
Second. Motion. I'm sorry, I'm ahead of myself.
Mr. Jensen moves, Vice Chair Cobbins seconds. Are there any questions?
I do have, after we vote,
Okay.
comment.
Okay. Any questions? I'll just say that, we visited the University of Memphis School when we were there last year, and what an outstanding school it is. And so, I think it's a great model. Go ahead.
I do have a couple of comments on this. The University of Memphis has been very successful in what they've done. They just opened another elementary school last week, and they're serving a population that's underserved. And they've got, I think it's 1,500 people on children on a waiting list to get in the school. One of the challenges that they have is the funding for the first year. And I don't understand all the ifs, ands, and buts about it, but if the child they cannot get that first year funding to start a school. So they have to wait, and it's just, either have to come up with, if they have 100 students, they have to come up with a whole lot of money to get that first year going, then they're fine. I don't know if that's a refer back to, I know Representative White is aware of this, but I just think we ought to be on record that ought to be looked at carefully and see if that, and I know there's a fiscal note with it, I know all the challenges of it, but they could, it is amazing what they have done in a short amount of time. I think they're up to the 10th grade now, and they've got 2 elementary schools, and as I said, a waiting list. It's just pretty amazing. And I think, if I'm not mistaken, MTSU, maybe, that may not be public, but they're pursuing it. There may be other universities that are doing that as well. So it's now public. But I do think that that innovation is really making an impact. And I just think we need to think about it. But that funding piece is
that because like TISA funding comes the year after the following year?
School district.
Yeah, right.
But it could be remedied with I realize there's a fiscal note that goes with that, but it's not impossible, right?
It was a decision to become an actual school district, so that was very intentional. So, yeah.
Other questions or comments? We have a recommendation, a motion, a second for Innovative School Districts Rule 05200125. This is a final reading, so we'll require a roll call. Mr. Griffin.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf?
Aye.
Mr. Mullenhour?
Aye.
Ms. Sapp? Mr. Wells?
Aye.
Mr. Chairman?
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. Thank you, Ms. Ye. Next item is Educator Licensure Policy 5.502. Taylor Reed.
Good morning, Taylor Reed, Senior Director of Licensure for the department. Tennessee State Board of Education Educator Licensure Policy 5.502 outlines general licensure requirements, including application and duration of licenses, professional development points, and endorsements. Over the past several years, Tennessee has worked to establish integrated endorsements, including both general education and special education for teacher candidates in pre-K through 3. To accommodate specific circumstances, this item revises the endorsement section by removing the 2026 retirement dates for the applicable early childhood endorsements. Rescinding these sunset dates supports licensure reciprocity for out-of-state educators and provides reactivation pathways for Tennessee educators with expired licenses. These changes help expand the educator workforce and allow local education agencies, or LEAs, to address critical staffing needs. There have been no changes since first reading. The Department of Education recommends approval of this item on final reading. The SBE staff concurs with this recommendation.
We have a recommendation on Educator Licensure Policy 5.502 on final reading. Is there a motion to accept that?
So moved.
A motion, is there a second?
Second.
Ms. Maxwell seconds. Any questions for Ms. Reed? No questions then. All in favor of accepting Educator Licensure Policy 5.502 on final reading, signify by saying aye. Aye. Opposed? Motion carries. Next item is Graduation Requirements Rule 0520010306. Dr. Jennifer Jordan, before we do that, we have had a few folks who've signed up for public comment, and so I would like to recognize each speaker for 3 minutes. I think there's 6 from one high school and one other one on top. So Matthew Harrison, you'd like to approach, and they say maximum 3 minutes.
Okay, on is better. Thank you and good morning, Mr. Chairman and members of the board. My name is Matthew Harrison, and I am the Department Chair of World Languages in Sullivan County Schools. Having already spoken on the importance of world language as a graduation requirement in a prior meeting, I originally planned only to introduce my students who are here today to speak to you, but after reviewing yesterday's work session video, I had a couple additional comments that I wanted to share beforehand. First, regarding university admission requirements and the importance of completing 2 credits in one world language. I can't speak for all universities throughout Tennessee, but I can speak for those which my students often attend in East Tennessee. ETSU, Milligan, King all require 2 units of the same foreign language for admission. The University of Tennessee and Tusculum, while not requiring it, strongly recommend 2 credits in the same language, as it increases the likelihood of a student's successful admission. These requirements are all verifiable on their websites. Second, in response to the comment that world language is not for everyone, I'd like to point out that many of us, myself included, have never used many concepts from Algebra 1, Algebra 2, geometry, or calculus in our adult lives, yet 4 credits of math are still required. Spanish is applicable to nearly every career in the global economy in which we live. Third, while staffing shortages were raised as a concern for world languages, we're not considering removing math and science requirements for the same reason. I'd also like to take this time to highlight the Niswonger Foundation, which can fully staff an entire school's language needs overnight with their program of asynchronous courses staffed by licensed Tennessee teachers. This program also offers languages like Latin, French, Spanish, American Sign Language, and many more, which can solve the issue of students wanting to study languages not offered at their school. While I can't speak to Mr. Eby's experience with asynchronous learning as an educator who teaches world language asynchronously at both the high school and the university level, and as someone who has taken numerous graduate courses in online pedagogy specifically, I can assure you that these courses are equally rigorous, they are pedagogically valuable as in-person instruction. We do live in the 21st century where learning is possible in a variety of formats using a variety of technological tools. Finally, in regard to the purpose of these courses and the concept of exposure, While it may be unrealistic to expect fluency after 2 courses, that exposure is indeed still valuable. Pathways also exist for students to continue their studies in higher level and AP courses to achieve greater fluency. It's also important to note that the new world language standards are based on proficiency, not on rote memorization, as many of us may have experienced in school. In conclusion, if my professional opinions as a former college admissions representative and academic advisor, an experienced K-12 world language educator, a 2-time district teacher of the year, and an adjunct professor of Spanish are not enough, I do hope that the students who follow me today will make a lasting impression on your memory as you weigh this immensely important decision. These are, after all, the very humans whose lives are impacted by your vote.
Your time is up, sir.
Thank you.
Thank you.
One last thing I do want to share. They felt so strongly. They did travel 5 hours in the car. They are missing school today with an unexcused absence to be here for you, and they did pay for lodging last night out of their own pockets. So I do implore you to please listen to their thoughts. And thank you, and sorry for exceeding the time.
Thank you. Addison Holly.
Good morning. I'm Addison Hawley, a 2025 Sullivan East High School graduate and proud former student of Mr. Matthew Harrison. I'm beyond honored to be here today to speak about something that I'm extremely passionate about because it's truly changed my life. I'm here to advocate for Spanish as I have personal experiences that give me great confidence and passion for this topic. Moving on to my personal experiences. Learning a second language from the ground up improved my English tremendously, as well as bettering my understanding of culture and diversity, which is crucial. High school Spanish allowed me to travel abroad to a Spanish-speaking country where I was able to communicate with confidence and display my skills. Doors have been opened in my life forever due to my education and being bilingual. For example, I began a job in healthcare this beginning of July and working as a certified clinical medical assistant, which I obtained through TCAT in December, 5 months before graduating high school in May. It was mentioned in yesterday's workshop that world language requirements take away from the time students have to take classes such as CTE courses. But I'm proof that if a student wants to take those classes and even obtain a certificate before graduating high school, that world language requirements do not hinder those opportunities. Going back to my job, in just 1 month, I've had multiple patients who speak Spanish and very little to no English at all. Without my Spanish experience beginning in high school, I would not have been able to provide those patients with the care they deserve. As a result of my education, I feel confident, but due to the future students who will not have gained this same confidence because of the lack of education. This is proof that as a student going into healthcare, it's safe to say I will have a better chance of getting any job due to being bilingual over any other person who's not. And this is not just for healthcare. This is for every career field. Not only have I used Spanish in my job, but taking Spanish in high school allowed me to complete all of my college Spanish requirements as a junior in high school. This allows me to begin my Spanish minor as a freshman in college. It was also mentioned in yesterday's workshop that world language isn't for everyone, and I do agree that not everyone's passionate about it like I am, but that does not take away from the fact that world language is so much more than just learning a language. It's about learning culture, diversity, building a work ethic, and even creating perseverance. With that being said, any student who does not pursue a minor or a major in Spanish in college is completely finished with their college Spanish before they even begin college. This saves every student thousands of dollars and so much time, and it puts every student ahead of others. So why take away something that is striving and impacting so many lives? Why strengthen the diversity that we have worked so hard to destroy? Furthermore, I love to learn. I'll be a lifetime learner, and taking Spanish away from students like me who want to learn and better their future limits and takes away so many opportunities that do not need to be taken away. And people like Mr. Harrison, who has changed my life completely, need to be in the classroom educating students and changing lives. They need to be opening doors and providing opportunities without having to worry about it being taken away. In conclusion, removing Spanish limits students' ability to thrive in an increasingly diverse and global world, because Spanish is practical, it's accessible, and it's a beneficial language that prepares students for real-world successes. Thank you for your time.
Lexi Rodriguez Alvarez.
Hello. It's being able to problem solve better, to think better, to be more adaptable and more empathetic.
It's the feeling when we make friends with all the neighborhood kids. The feeling when we travel abroad and can read the street signs, buy ourselves a meal. It's a feeling of capability, community, pride. That is what we are taking away if we do not oppose this. It's that feeling we are taking away, not just a requirement. Today we will be talking about youth, your children, friends, and neighbors, and how we are in dire need of your opposition to this requirement, to the consideration to remove this requirement. One can say that I'm a credible source on this topic because of my experience as a world language student, a 3-sport varsity athlete, a Spanish peer tutor, a teen about to get my high school diploma and associate's degree simultaneously, and because of the research I have done, and because of my passion for languages too. I could not tell you if it's my roots, my peers, or my schools, but these courses have impacted my life like no other. They have bettered me in more ways than I can count on both my hands and the helping hands of all the wonderful teachers in the state. World language classes have opened my eyes, and from what I have seen, they have opened the eyes of many of my fellow high schoolers as well. After all, it was through those classes that we had to take and therefore had to benefit from, that we gained the ability to understand and value others more. Even the National Library of Medicine has verified that learning another language helps build empathy and cultural awareness. This is confirmed in the 2019 article titled Role of Bilingualism and Biculturalism, as the National Library states that students who learn more than one language have a certain openness to diversity and increased empathy. In addition, it was world language classes that enabled me to travel abroad, to follow my dreams and visit places I may have never gone otherwise. That's another way that these classes have bettered me and wouldn't have been able to if I hadn't been required to take them. I would not have been where I've been and be who I am today without the guidance of these courses. After all, even after we book our flights and reserve our rooms for our dream trips abroad, we don't speak the local languages, and that can be rather intimidating. But the world language requirement changes that. The requirement makes us learn how to call for help in those local languages, how to order breakfast, to say our names, and to have better experiences abroad as a whole. Therefore, the next time you hesitate to book the dream getaway with youth, know that they have been given the skills to navigate abroad. The next time you see someone struggling and speaking a foreign language, know that the youth have been given the skills to help and translate. And the next time the youth talk about the world language requirement, know that it is solely built to benefit both them and you. I hope that everyone here now understands the importance of the world language requirement and will oppose the consideration to remove it.
Thank you. Aldero Ortiz.
Thank you, members of the board. My name is Aldo Ortiz, and I am currently a student at Sullivan East High School and currently enrolled in several college classes at Northeast State Community College. I'm here today in response to the policy shift regarding removing world language as a high school graduation requirement. This change in policy would have detrimental consequences for world language program staffing, and most importantly, students like me and my peers. While most of my classmates and I have already earned the required world language credits, many students across Tennessee have not. Without these opportunities, their ability to compete in a global economy, connect with diverse cultures, and think critically across perspectives will be severely diminished. Eliminating or reducing world language requirements would not only hinder individual growth, but also weaken Tennessee's position on the national stage, leaving our students less prepared for college, careers, and the world beyond. In my 2 years of taking the Spanish classes offered at my high school, I have been astonished with how much not only mine but my peers' Spanish skills have improved, but as well as our overall intellectual development. After Spanish 4, I was able to earn 12 college credit hours at ETSU and 6 college credit hours at any college of my choice by taking the CLEP exam, at absolutely no cost to me. More benefits include enhancing creativity, problem-solving skills, and critical thinking. All these are fundamental skills that help students like me go further in life. In Spanish class, I didn't just improve my Spanish skills, I also improved on my English, grammar, reading, and writing, as well as my communication. I also learned geography, history, and cultural understanding. These things that I've learned and improved on are vital for the path I choose to follow, not only in the future, but in the present as well. Coming from a Spanish-speaking household, it was hard for me to connect with my dad, who was born and raised in Veracruz, Mexico. He is bilingual, speaking both English and Spanish very well, but now I feel more connected with him because I can now communicate with him in Spanish better than I ever have. Because of what I've learned from my teacher, Matthew Harrison, in the Spanish class that he teaches. I firmly believe Spanish should stay as a graduation requirement, not for the sake of maintaining the world language programs throughout Tennessee, but for us students that need to be prepared for our future endeavors and opportunities. Not only did this program shape the way I view the world, but the way I think and speak. The removal of this requirement will set students back and take away opportunities they could have but never knew about. Students need programs like this for the opportunities that come with it. Thank you.
Thank you. Brendan Brush.
All right, thank you, Mr. Chairman and board members, for allowing all of us to have a voice today. My name is Brendan Brush. I'm a former student of Sullivan East High School, and I'm a current student at Tennessee Technological University, studying both a Bachelor of Science in Mechanical Engineering with a concentration in aerospace, alongside a Bachelor of Arts in Foreign Language and in Spanish. I'm here today to not only confute the policy shift put forward by Chairman Eby during the May 30th meeting concerning the removal of world language as a graduation requirement, but to also challenge the ideology behind its original proposition. When I was in high school, studying was a foreign concept to me. Test after test, A after A, I never needed to apply myself, practice concepts learned in class, or develop a work ethic, simply because everything was easy. I went into my first Spanish class at Sullivan East secure in my belief that I would sit down, listen to my teacher talk, and breeze right through the course. Emphatically humbled, I left that room with the realization that I was incompetent and void of the ability to critically think. For the first time in my life, I needed to incorporate personal effort and accustom myself to a completely different practice of education. Although it was difficult for me to come to terms with the fact that I was not prepared for further, more difficult studies, it was an absolute necessity for me to ascertain that unfortunate reality earlier in life rather than later. By being obligated to take 2 years of a foreign language, I have grown to extensively appreciate each of my peers, and I have excelled academically in a field whose foundation is built upon studies in science, technology, engineering, and mathematics, due to the fact that fundamental principles of being a successful student and a caring individual were taught to me in a Spanish class rather than a STEM course. I am now going to focus on a couple of statements made during the May 30th meeting. To quote, if their ultimate path of their post-secondary success does not include utilization of a foreign language. Although it was stated that students should not be required to study topics under world language because the students know that they themselves will not use it, the same statement can be made towards classes rooted in STEM, given that not every student will enter a field whose foundation is based upon studies in STEM. To quote, how often have you used your foreign language you took in high school during your career or lifetime? To inquire analogously, how often have you used the quadratic equation that you learned in algebra to find the real roots of a second-degree polynomial? The answer is most commonly, very rarely, or never, but the rigor of learning such a skill is imperative to cognitive growth. Mr. Ryan Holt did a phenomenal job explaining that during the May 30th meeting. To make it clear, there is no doubt in my mind that Mr. Chairman Eby desires the best possible outcome for the students of Tennessee, and I do not condone impertinent remarks made towards him, the board, or the board members. I commend you for making your opinion public because it is difficult to know that your opinion is differing from the rest of the state, so I commend you for that. There is no need, however, to experiment with upcoming students because data that suggests a growth in post-secondary success on the basis that the requirement is removed does not exist. So I have to say that proposing to eliminate foreign language requirements for high school students in Tennessee is fiercely ill-informed. Thank you.
Thank you. Emma Hatcher.
New phone.
That's okay.
There we go. All right. Good morning. If I look familiar, it's because I am. I've been here before. All right. The last time I stood here, I spoke from the heart about my personal journey and what language has meant to me.
But today I want to speak more from numbers and facts and data about the real cost of this debate and the effect it's had on me and other Tennessee students. Now, I am a language major, so I could stand here for hours telling you about the cultural, academic, and cognitive benefits of bilingualism, and trust me, I will. But also, I am getting a dual degree in business, which means I'm qualified to talk to you about the numbers as well, because I pay for it. Alrighty, let's talk economics first. Bilingual employees earn anywhere between 5 and 20% more per hour than their monolingual peers. Over a lifetime, that's as much as $128,000 more in additional income. In some countries, like Switzerland, multilingualism boosts the economy by 10% of their GDP. In today's global market, speaking only one language is like trying to compete with only one hand tied behind your back. Tennessee students deserve to enter this market with both hands free. The cognitive science is just as clear. Language study strengthens problem-solving skills, improves memory, boosts multitasking, and even delays cognitive decline later in life. It raises standardized test scores, sharpens literacy, and fosters cultural empathy. These are not bonus skills. They are core tools for success in college, careers, and in civic life. Now, let's talk about what this cost me. I've spent $149 on a hotel to be here. I've spent $100 on gas and $100 in food. I'm just trying to think about how many times I'm going to have to come back down here to talk to you about the importance of this, because I work for my money. I'm a waitress. I wait my tables in Spanish sometimes, and I have specific customers who come in just to see me because I'm able to speak to them, to understand them, and I want to. I've chosen to spend my dollars here. I'm speaking today not just because this matters not only for me, but for the students who don't have the resources or the flexibility to be here. There are several students who have sent me letters today that I would love to share with you that were not able to be here. I'm here for them. Removing this requirement is not streamlining education. It's stripping away an essential skill that supports academic achievement, career readiness, and economic competitiveness. I will keep coming here on my own dime because I believe every Tennessee student should have the chance to speak, think, and succeed in more than one language. I'm asking you, don't take that chance away. Keep the foreign language requirement. Protect the opportunity it represents. Thank you.
Thank you. Pat Sheehy, Tennessee Business Roundtable.
Good morning. I'm Pat Sheehy, president of the Tennessee Business Roundtable. Our statewide business organization was founded at the suggestion of then Governor Lamar Alexander in 1983. Today, our roundtable is comprised of 60 companies and organizations from nearly every corner of Tennessee and representing nearly 20 business sectors. I want to speak briefly today about item 6C on today's agenda, the proposed changes to the graduation requirements rule. As we understand them, the changes under consideration today are intended to promote alignment and inclusiveness, which are good things. The provision clarifying the application of the computer science standard to the alternate diploma requirements seems to be intended to ensure that students pursuing alternate diplomas receive a knowledge base that's aligned to that which is required for a traditional diploma, and we support that. The provision proposed to update the graduation distinction requirement to reference all state arts organizations seems to be intended to ensure that other art disciplines receive the same recognition currently afforded to musical organizations with reference to this distinction, and we support that as well. Although it's not included in the revisions to today's final reading item, I do want to take this opportunity to offer some thoughts from our business roundtable regarding the potential change to Tennessee graduation requirements, which has been proposed for discussion by the chairman. In response to concerns expressed by parents, students, educators, and student advocates, the chairman has put forth the idea of changing the graduation requirement for world languages. And as we understand it, he has suggested that the current 2-credit requirement be converted to 2 additional elective focus credits, which students could then use to take world language courses or other courses. We understand that the motivation for this suggestion is to enhance flexibility for Tennessee students to pursue academic courses of study which best align with the post-secondary pathways that they are considering or that they are choosing. In particular, during the discussions hosted by the state board staff with the chairman and other board members and stakeholders, we learned that many view this suggested change as an opportunity to increase the number of career and technical education courses they can complete prior to graduation. While our business roundtable has not yet determined its official position on this idea, we are actively discussing the opportunities and risks that it might offer, and we encourage the board and all other stakeholders to do the same. From our perspective, the prospect of increasing pre-graduation attainment in career-connected courses of
Thank
study
you.
seems valuable and worthy.
Thank you. Thank you to each one of you who came, spent your own dollars to come. It reminds me when I've told this board before, became the chairman, I wanted to learn how to be the best, most effective chairman I could. And I think I heard today a lot of people talking about learning. And I developed an acronym for LEARN. L, listen. That's the first letter, listen first. E, engage. How do you best listen is by engagement. A, act. Act only after you've engaged and listened. R, respect. Even though you may not agree with opinion, respect the opinion of others. And then if you go through the LEAR, you get to N, and you can navigate through the process. And I really appreciate each one of you taking the time to come and present your position. I've learned from it. Thank you. Dr. Jennifer Jordan.
Good afternoon now. Jennifer Jordan, Assistant Commissioner of Special Education and Student Supports at the department. I'm presenting Graduation Rule 0520-0103.06 on final read. The Every Student Succeeds Act, or ESSA, allows states to adopt alternate academic achievement standards for students with the most significant cognitive disabilities. But the state's alternate academic achievement standards must be aligned with the state's traditional academic achievement standards. TCA 49-66001 requires the State Board of Education to ensure that alternate academic diploma requirements are aligned to the traditional high school diploma requirements. TCA 49-60101B and Tennessee State Board of Education graduation requirements Rule 0520-0103.06 require that a high school student pursuing a traditional high school diploma receive at least 1 credit of computer science education in high school. To ensure alignment between the traditional high school diploma requirements and the alternate academic diploma requirements, this item proposes revisions to clarify that a high school student pursuing an alternate academic diploma must receive at least 1 credit of computer science education in high school, although the course may be modified based on the student's individual needs. This item also updates terminology and the requirements for the state graduation distinction from all state musical organizations to all state arts organizations to recognize that the other art disciplines, which still include music, now have a mechanism to determine all state status. State board staff held a rulemaking hearing on July 24, 2025 to collect public feedback. No public comments were received regarding the proposed revisions. There have been no changes to this item since first read. The Department of Education recommends approval of this item on final reading. The SBE staff concurs with this recommendation.
Thank you. We have a recommendation on final approval for graduation requirements Rule 0520-010306. Is there a motion to accept?
So moved.
Vice Chair Cobbins moves. Is there a second? Ms. McInturf seconds. Are there any questions for Ms. Dr. Jordan? No questions. Since this is a rule on final reading, we'll call a roll call vote. Mr. Griffin, please call the roll.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
The motion passes. Next item is functional behavior assessments and behavior intervention rules 0520-010924. Dr. Jordan again.
Thank Thank you, Chairman. Jennifer Jordan, Assistant Commissioner of Special Education and Student Supports at the Department. I'm presenting on final read the FBA, or Functional Behavior Assessment and Behavior Intervention Plans Rule 05200109.24. The Individuals with Disabilities Act, IDEA, and state law requires students with disabilities to be educated alongside their non-disabled peers to the maximum extent appropriate. Students with disabilities may be removed from the regular education environment only when the student's Individualized Education Program, or IEP, team determines that the nature or severity of the student's disability does not enable the LEA to satisfactorily educate the student in regular classes with the use of supplementary aids and services. In 2022, the State Board of Education promulgated rules requiring LEAs to conduct a functional behavior assessment and develop or revise a behavior intervention plan in certain circumstances, including when the student exhibits a pattern of behaviors that impede the learning of the student or others, and when the student exhibits a pattern of behaviors that place the student or others at risk of harm or injury. Since that time, the Tennessee Department of Education has consistently received feedback from LEAs about the challenges in educating students with disabilities who are presenting significantly dangerous or disruptive behavior. This proposed item clarifies that a functional behavior assessments and behavior intervention plans rule 05200109.243 does not prevent LEAs from moving a student who threatens the safety of other students or poses a danger to him or herself through a pattern of behavior if placed in the regular classroom to a more restrictive environment, nor from conducting an FBA or developing a BIP while the student is in the more restrictive environment. Changes have been made between first and final reading, provide additional clarity to the revised language. State Board staff held a rulemaking hearing on July 24th, 2025 to collect public feedback. 4 written comments were timely submitted and were provided to the board members for review. Between first and final reading, revisions were made to better clarify that a student's IEP team may adjust the student's least restrictive environment in accordance with IDEA without first conducting an FBA or BIP. The Department of Education recommends approval of this reading on the final reading. The SBE staff concurs with this recommendation.
We have a recommendation for functional behavior assessments, behavior intervention plans, 0520010924. Is there a motion to accept?
So moved.
Mr. Mullenhour moves. Is there a second? Ms. McInturf seconds. Are there any questions? Vice Chair Cobbins.
Just want to share a couple of comments. I know we got a lot of emails and communication from parents and advocates on this particular item. And it took me some time to sort of round out my perspective on this, both as a parent of a non-divergent son, but then also as someone who has to sit here and make policy that'll impact students across the state. So spent some time this week talking with Mr. Jenkins and State Board, TDOE staff on this, and I think it's important that we make clear what's happening here, because in some of the communication that I've read from parents and advocates, there seems to be a little bit of confusion that this rule has been in place for 3 years now. So this is not something that is coming forth just now. And we're making these modifications based on feedback, as you mentioned, that we've gotten from LEAs. And so a couple of things that I wanted to be certain of on this was, one, that the language here seems to address sort of a specific scenario or situation where safety and security is in question, and a decision has to be made at that point. And moving the student to the least, or adjusting what the least restrictive environment is for that student is a decision that has to be made not just by one individual, but by a group of individuals that comprise that IEP team. And so I just want to make sure for the audience and anyone watching that you know, there should not be a capricious decision by any one individual that a child should be removed from a particular environment in that instance. And so allowing for that to be done without the FBA or the BIP does not negate that an FBA or BIP will be done once that transition occurs. And so I just want to make sure that everyone understands that that will still be done. It just will be done under the sort of environment that that child has been transitioned to. Also want to make clear that I've learned through this process that parents have a route to appeal.
Yes, sir.
And that, and Mr. Jenkins shared with me that that is actually his team that would field those appeals if there's an instance where a parent feels as though their child is not being served through that decision, or they have some issue with that decision that's been made. And so one of my chief concerns was whether through this it would potentially become the first resort as opposed to the last resort. Through this conversation over the course of these few days with Mr. Jenkins, I have arrived at a certain point of comfortability that it should not be a first resort, and that, you know, there's a process in place both for the decision being made, but then also parent empowerment on behalf of their child and student, that if they feel like that has not been done in a way that's conducive for that child, that there's a route for that to be addressed. And so thank you all for your hard work on this. I know it's not easy. You know, I've walked the journey for 16 years now, so a lot of the emails and communications that we've gotten, my wife and I have lived that. So we understand the challenge on the side of the parents and the students and those that advocate for them. But in this particular situation, I've looked at it from an angle of dealing with a specific instance and situation in this regard that that from time to time presents itself and needs to be addressed with some immediacy. So thank you for clarifying those things for me. Hopefully this conversation just now is clarifying for some of the people who have reached out with comments and public comments and emails to us that that this is to address a specific situation or issue.
Thank you. Mr. Mullenhour.
Mr. Chairman, thank you. I would just echo our comments from our Vice Chair Cobbins and just say that I appreciate the depth of the perspective that you brought to bear in this case. You have experience that definitely will inform better judgment in this arena. And I would just say also thank you to Taylor Jenkins. He was able to answer a number of questions that I had on call this week as well. It's very helpful. So thank you for your comments, Mr. Cobbins.
Other questions or comments? We have a motion and a second for functional behavior assessments and behavior intervention plans, Rule 0520010924. All roll call. Mr. Griffin.
Lost my place.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf. Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. Thank you, Dr. Jordan.
Thank
Next
you.
item is individualized education accounts, Rule 0520011102. Mr. Taylor Jenkins.
Thank you, Chairman Eby. Taylor Jenkins, Deputy General Counsel, the Department of Education. I'm here to present a proposed revision to Individualized Education Account Rule 0520-01-11-.02. This is a simple change. So as you know, the Individualized Education Account Program is a school choice program for students with qualifying disabilities. Chapter 235 of the Public Acts of 2025 added a new disability to the list of qualifying disability categories, and that is of deafness. And so this proposed revision is simply to ensure alignment between our state statutes and the State Board of Education rules. With that, I'm happy to answer any questions you have.
We have a motion for Individualized Education Accounts Rule 0520-01-1102. A recommendation. Is there a motion to accept? Mr. Jensen moves. Is there a second?
Second.
Ms. Maxwell seconds. Are there any questions for Mr. Jenkins? No questions. Mr. Griffin, please call the roll.
Mr. Cobbett.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Eby.
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. Thank you. Next item is Accountability Hearing Rules 0520-09-02-01 through 04. Ms. Allie Reed. Ms. Reed, since we had a workshop on this yesterday and all, could you kind of summarize your thoughts and comments up front
About accountability hearings?
about this rule? In other words, don't read through everything that's in here
Yes.
on this page. I'm looking at our clock and
I was
time.
not planning to, thank you. Yes, I can do that. So, Allie Reed, Director of Engagement and Accountability for the State Board. This is a final reading for our accountability hearings rules, which was previously before the board on first reading back in February. So as you may recall, as part of the TISA Act, the State Board is authorized to conduct hearings of LEAs that operate public schools that receive a D or an F letter grade, as well as public charter schools that receive a D or an F letter grade, to report on the school's performance and how their spending decisions may have affected those performance goals. So over the last 3 years, our staff has been conducting significant research, consultations, and stakeholder engagement to arrive at the proposed rule before you today. And there have been several changes since first reading in response to both your feedback that was discussed during the February meeting, as well as stakeholder engagement in a rulemaking hearing. And those changes are available on the cover sheet, so I won't read them all. Our staff has also presented on the proposed rules and hearings process at various meetings and conferences around the state for the last year, and incorporated feedback whenever possible. So following your approval today, our staff will begin preparing for the first set of accountability hearings, which are scheduled to take place in March 2026. Happy to answer any questions.
Thank you. We have a recommendation for accountability hearings 0520-09-02-01 through 04. Is there a motion to accept on final reading? Vice Chair Cobbins moves. Is there a second? Ms. Johnson seconds. Are there any questions for Ms. Reed? I have one. At what point in time, maybe this is for TDOE, do we expect to know how many hearings, how many schools will have accountability hearing rules associated with?
We expect that the letter grades will be released via the report card in December, as it has the last few years, but also looking to you to confirm.
Yeah, that'll be around that time.
Perfect. Yep, so we will then determine who will be called for the hearing once those letter grades are released.
Okay, thank you. Any other questions or comments? None. We have a recommendation on accountability hearing rules 0520-09-02-01 through 04. All this would recall a roll call.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Chairman Eby.
Aye.
Mr. Chairman, you have 9 ayes.
Thank you, Ms. Reed. Motion passes. Next item is educator licensure rules 0520, 02, 03, 02, 07, 11, 12, and 13. Ms. Taylor Reed.
Good afternoon, Taylor Reed, Senior Director of Educator Licensure. Tennessee State Board of Education Educator Licensure Rules 052003 outline the license types issued in Tennessee and pathways towards licensure. Rule .02 outlines the different types of educator licenses. Rule .07 governs the issuance of post-secondary educator licenses, and Rules .11 through .13 outline the requirements for emergency credentials and limited licenses. Chapter 328 of the Public Acts of 2025 took effect on July 1st, 2025, and made various revisions to educator licensure laws. This item makes corresponding revisions to various sections of the licensure rule to align with PC 328. Adding the limited occupational teaching license to eligible license types, allowing additional endorsements on subsequent post-secondary educator licenses, removing prohibitions on end-of-course exams in elementary physical education courses for emergency credentials and limited licenses, eliminates the outdated occupational permit requirements, of course replaced by the limited occupational teaching license, and establishing and updating criteria for issuing, renewing, and advancing the limited licenses, both academic and occupational. This item is proposed as an emergency rule to ensure the rules are in effect by the 2025-2026 school year and meet the public chapter's effective date. A permanent version of these rules is now being heard on first and final reading at the State Board meeting. SBE will host a rulemaking hearing for the permanent rule between first and final reading. The Department of Education recommends acceptance of this item on first and final reading. The SBE staff concurs with this recommendation.
We have a recommendation for educator licensure emergency rules 0520, 02, 03, 02, 07, 11, 12, and 13. Is there a motion to accept? Thank you, Mr. Jensen. We have a motion. Is there a second? Ms. Maxwell seconds. Are there any questions for Ms. Reed? No questions. This is a rule on final reading. Ms. Griffin, please call the roll.
Mr. Cobbins.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. Thank you, Ms. Reed. Next item is educator preparation providers and specialty area programs approvals. Dr. Jennifer Nelson.
Good morning, or afternoon, I should say. Jennifer Nelson, Senior Director of Educator Preparation. This item delivers action recommendations for educator preparation providers, or what we also call EPPs, and the related specialty area programs, what we also call SAPs. Lee University participated in an AQUEP review in spring 2025, and they met all national standards with no deficiencies. The review team recommends Lee University for full approval and initial accreditation. Lee's fall 2024 SAP review showed all specialty area programs meet expectations, and the review team recommends full approval. Rhodes College participated in a focus review in fall 2024, and the review team found all standards were met with one minor stipulation. Rhodes specialty area programs fully meet expectations. The review team recommends full approval with minor stipulations, and the SAPs, or specialty area programs, are recommended for full approval. Cumberland University previously held full approval with minor stipulations. Since 2021, the department has worked with Cumberland with their annual progress monitoring. The reports show improvements of meeting expectations, and the department recommends removing those stipulations and changing Cumberland's EPP status to full approval. And last, the department reviewed the Teach Wilson County proposal for a recommendation of initial approval. The department review team concluded that Teach Wilson County meets expectations on the initial EPP proposal and recommends initial approval for endorsement in CTE occupational. The Department of Education recommends acceptance of this item on first and final reading. The SBE staff concurs with this recommendation.
Thank you. We have a recommendation for education preparation providers and specialty area programs. Is there a motion to accept this recommendation? Mr. Holt moves. Is there a second?
Second.
Mr. Mullenhour seconds. Are there any questions? Yeah. Vice Chair Cobbins.
Just like to disclose that I'm an alum and trustee of Rhodes College, so for the record.
Great. Well, congratulations on that. I know. I got you. Any other questions, comments? Anybody else graduate from one of these schools they need to disclose? If none, Mr. Griffin, would you please call the roll?
Mr. Collins.
Aye, and go Lynx.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Ms. Johnson.
Aye.
Ms. Maxwell.
Aye.
Ms. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Ms. Sapp. Mr. Wells.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, you have 9 ayes.
Motion passes. Thank you, Dr. Nelson. That concludes our items on final reading. We'll now go into other business. I think
I do have
think Mr. Jensen has a
request
comment. Yep.
for information, and this may be on the Department of Education website, but I'd be very grateful to know on the Education Freedom Scholarships, total number of applications, the total awarded, and it's delineated between two groups. I'd be interested in the geographic distribution, as well as the distribution by grade level, and then what is next. I know there's some provision in the law that they can go back and ask for another 5,000 or something. So just some level of information, total number of schools that are participating, so that we're able to talk to the folks that we represent about this is what has occurred.
You bet.
Any other final items? I'd just like to say to each one of you, I really appreciate this board. I mean, the commitment that the board has towards the students across the state of Tennessee, the time that you spend. I don't know about you, but I'm tired. It's been 2 very productive days, I think, and 2 good days. I always look forward to the times that we can get together and have the discussion. Yeah, Mr. Wells.
I should have left you had the last word, but I didn't mean to do this. But I just want to say thanks for the students and former students that came and spoke earlier. Incredibly impressive. And Mr. Harrison, obviously you've won a lot of awards, but by your students being here and everything, I can assume you were a great teacher. So thank you for that.
I got one more thing.
Yes, Ms. McIntyre.
I'm extra proud because I'm a former Sullivan East High Patriot, so they made me very proud today.
Thank you. Other comments or questions? If none, this meeting is adjourned.